From item number 1 to 4.
Yes.
Number 5 to 12. 14 to 23.
Yes.
Mention item number 18, your lordship.
Yes.
1 week's time may be granted, your lordship, to file our affidavit.
To file a,
Affidavit.
do you have any objections, Simon?
No objection, my lord. That may fix, my lord.
State Council, you are for the state.
Yes, sir.
Place for and is granted a week's time to file an additional affidavit list on 3rd April.
Much obliged.
Numbers 25.
May I, please, Lordship? I beg to mention item number 25. Lordship.
Yes.
Lordship, Mr. T.J. Mahanta is appearing in this case, Lordship. I am for the respondent,
Mhm.
APSC. He is in bereavement, Lordship.
Okay.
This matter may be kindly taken up after 3 weeks, Lordship.
A request is made to adjourn the matter on behalf of Government Council,
Standing Council, APSC.
Standing Council APSC on the ground that he has suffered a bereavement. List after 4 weeks as per it.
Obliged, Lordship.
Yes.
My lord, item 11, my lord.
Page is gone, sir. Now wait for your turn.
Lordship, I would like to mention an item number 31, Lordship.
Yes.
Lordship, I am for the appellant, Lordship.
Yes.
May I pay this matter may be taken up after 4 weeks, Lordship. Mr. T.J. Mahanta is conducting the case.
It is stated that Land Council, leading council, Mr. T.J. Mahanta has suffered a bereavement in the family. And thus the matter may be adjourned. List after 4 weeks as per it.
Much obliged.
Yes.
Yes, my lord. I am praying for a listing of case, custom reference 1, 2, and 3 of 2022.
Of 2000?
2022.
Yes.
It was yesterday it was listed, but item did not reach.
Yesterday it was listed.
Yes.
We'll
But-
give a date in yesterday's matter.
Yes, sir, my lord.
Okay.
It is in the month of May, I have
We
seen.
give them a date
My
in
lord,
3rd
my
week of
lord,
April.
I pray for a March or April, it's a perishable goods. That's why decision. March or
Ninth, the
April.
date is already given, sir. Now you will have to file a preponement application. Date is already given. Yesterday we had given an option to the Learned Council to take a date. Probably you missed out. Yes.
May I please, Lordship, my lord, I'm praying for listing of matter, my lord. My lord, in this case, my lord, I have challenged, my lord, the auction, my lord, which is going to be held, my lord, on 24, my lord,
Okay.
day after tomorrow, my lord. So, my lord, praying
It's a
for
writ
listing
petition
of
or a writ appeal?
writ petition, my lord. Surface, yeah.
Surface.
Yes.
Get it listed on 24th.
My lord, 24 is the date of my lord auction.
Then when was the date fixed, sir?
No, date is 24, my lord.
When was the intimation received by your client?
My lord, only just 2-3 days before, my lord.
Let it come tomorrow. All right.
Only.
Okay.
Chief, I beg to mention read Bill number 72 of 2022. Lordship, this is a contract matter. There is a stay order passed in this matter as such. The bill is not passed yet. Matter was last posted on 21/2023, where it was directed to list the matter on 24/1/2023 for appeal hearing, but the same is not listed yet, Lordship. Matter may kindly be listed on 24th.
You just check with the registry why it has not been listed. We'll direct the registry to take appropriate action.
Yes, Lordship.
Yes.
Item number 1 for motion.
May it please your lordship.
Yes.
Also, the service of the petitioner is provincialized as tutor under the Provincialization Act of 2017. Now, the grievance of the petitioner is their lordship.
Fixed salary.
Yes,
Fixed
fixed
salary.
salary lordship. Although lordship ground that they are not having requisite qualification.
Right.
Now, the qualification is prescribed under section 6 by following the provisions of the NCT regulation.
Mhm.
Now, NCT, I have annexed the document. The NCT regulation says the teachers appointed prior to April 2001 for those teachers disqualification.
All right. Issue notice to the respondents. Third issue notice to the respondents.
This is connected to the series.
I think it is not connected because here let's say we have challenged the particular provision. Of
Who would be appearing?
This section 8.3 and 8.4 are under challenge.
Lordship.
Sections 8(3) and 8(4) under challenge in other matters.
Yes,
You are not aware,
I am not aware, Lordship.
not aware.
Because there is similar, also there is one more case that is pending. I have annexed
They will come out with the similar details.
Annexer A, the similar identical issue that is pending. Annexer 8, page 86, Lordship. 8, Lordship. Annexer 8, page 86. Here also the same rule is under to challenge.
Connect with so and so.
Here direction is
Appearances
given-
may be marked. Yes,
Well, Lordship, direction is given to state respondent to file affidavit in the earlier case.
the state council shall file affidavits within next 4 weeks, less thereafter.
Deeply obliged.
Yes,
Item numbers 2 to 4.
This is the revenue appeals income under income tax act. The respondent, they utilize their unutilized subsidy in the bank and
Yes.
deposit in the bank and earn interest.
yes,
CSET is held against the department. In my humble submission, Lordship, this is a capital subsidy and that is required to be assessed.
yes. The issues which you are raising are directly covered by, squarely covered by Bokaro Steel.
Lordship, there is a Lordship subsequent, there is a judgment of 2021 also, Lordship.
2021.
Lordship,
What is that?
sorry, 2012.
12.
I'm giving you.
Let's read from para 10 of the judgment, impugned judgment.
Lordship.
Yes. Then one more issue. Read para 2 of the impugned order. Bottom 4 lines. Learned AR drew our attention to the fact that all the issues raised by both the parties are covered by the decision of the tribunal in SSC's own case, so and so. Now, whether that order of the tribunal has been challenged,
Lordship, that I'm not aware.
that is the first observation of the tribunal. Now, para 10.
Thus, we note that the Honorable Supreme Court has answered the two questions in favor of the SEC since they are covered by Bokaro Steel and answered the question which is relevant in this case before us. As noted from the question of law framed by the Honorable Supreme Court in Karnataka Power Corporation, we note that the questions was whether the interest received of higher charges from the contract are in nature of capital receipts. Thus, we are not the Honorable Supreme Court in Karnataka Power Corporation held in favor of the SEC by following the ratio laid down in say versus Bokaro Steel. Lordship,
Yes,
there are two other judgments
let's see.
which were also read by the tribunal.
Yes. How do you distinguish Bokaro Steel?
Lordship, the facts of this case are different in my humble submission. Lord.
Then let's admit the Sraf, then let's admit the appeal.
My lord, I will, if you also permit me, my lord. Because,
It's an appeal, statutory appeal.
my lord, but the question that you know, you also may see the appeal
Yes.
of the appeal, my lord. Now, whether they have anywhere said that this is not covered or they have disputed the facts. They are not saying anything, my
They
lord.
are coming out with another proposition of law,
My lord.
which this is non-speaking order, don't worry.
No,
We'll assign
Lordship,
reasons.
no, Lordship, regarding admission of appeal.
We'll assign reasons. That was reversed because High Court did not assign reasons.
Yes,
Rest assured, we'll do.
Lordship, another 2000.
Yes,
In this, all these judgments were considered. Lord.
all right. This order will take care, don't worry. We'll assign reasons.
My lord,
You may carry our order to Supreme Court.
my lord, kindly see, my lord, page 39.
Yes,
Or paragraph, my lord, 11, the next page, my lord,
39.
my lord, of the tribunal's order. I am in fact appearing in item number 3, my lord.
Oh,
But the same order is there.
Yes.
After 5 or 6 lines, my lord.
Mm.
However, it was brought to my notice. Does you also got it?
However,
However, it was brought to our notice that in the present case, the SSC is a public sector undertaking under
Yes.
Ministry of so and so.
you are reading from para
11, not the next page,
para 11.
continuation next page.
Yes, yes.
No, no. However, it was brought to our notice in the just 7 or 8 lines, that in the present case, the SSC is a public sector undertaking in the Ministry of Chemicals, and it was promoted to undertake the Assam Chemical project, which was approved by the central government on economic effect for setting up an integrated petrochemical complex in the Assam, where it was estimated cost of so and so. We note that the project was under construction, had not been set up, and was not operational on the assessment year so and so. We note that the SSC has received so and so. You'll also skip over and thereafter next page, para 12 below.
Yes.
We note that the utilization of the funds available with the SSC is strictly governed by the object set up by the articles of issue of the company. The provisional of object clause indicates that there is no scope for SSC to utilize the funds available for any purpose other than the,
A very well discussed order.
and you'll also the last line below. Thus,
Yes.
we note that the interest earned by the deposit to the mandatory invested in the project business of the SSC, and in the facts and we note that the interest of borrowed capital in so and so deposited in the bank in inextricable link to the setting up of the plant.
Inextricable link.
And
Yes.
the Bokaro Steel Mill, you also see the judgment. I will just give the judgment. No?
Yes.
First today.
Bokaro Steel.
No, that is what I said. Bokaro Steel marking too. Ele tá sentando, eu tô copiando. At page Milord 653. Ele tá sendo temporada por favor.
Para
Milord, just give me that. 653 Milord.
6.
Paragraph starts from paragraph 7 Milord.
Yes.
You'll also see the
Borrowed funds.
Milord. However, you'll also see the page
Yes.
653. However, while interest earned by the investing borrowed capital in short-term deposit is an independent source of income and not connected with the construction activity, business activities of the SSC, the same cannot be said to be present case, where the utilization of the various assets of the company and the payment received for such utilization are directly linked to the activities of setting up of the steel plant of the SSC. Now, in this case, the tribunal has come to finding, Milord, that this was strictly, Milord, only for the setting up of the plant.
Yes.
And you'll also see the last 5 lines of that one, Milord, of the paragraph. In case the money is borrowed by a newly started company, which is the process of constructing and erecting its plant, the interest incurred before the commencement of the production on such borrowed capital can be capitalized and added to the cost of the fixed assets created as a result of such expenditure. By the same reason, the SSC receives any amounts which are intrinsically linked with the resources process of setting up the plant, which receipts will go to reduce the cost of the receipts. These receipts are capital receipts and cannot be taxed as income. Now, my lord, the tribunal's finding is not under challenge. Now,
Which finding?
this is my lord, to be admitted, and once the facts are admitted, my lord, then the decision is already there.
Finding regarding?
Well, that this expenditure, the receipts, were for the setting up of the plant.
That is under challenge in this appeal.
No, there's not any challenge. You'll also see.
Read, please. Read from the pleadings. Read.
The grounds which are there, my lord.
Yes, please. Page number
Page 6.
6. Yes, let's see.
You'll also see. For that, the tribunal was not a justified committee manifesto of law by allowing the appeal of the so and so. That the tribunal erred in concluding that the interest income earned from the short-term deposits or so and so utilized should be treated as capital receipt and not to be treated as the income from other sources. Thereafter, also see 4. For the tribunal erred in law and concluding that the interest income earned from the short-term deposits bank equally should be treated as a capital receipt. That the tribunal erred in law in fact by holding that the interest in short-term deposit utilized by was a capital receipt. There is no final challenge. And these questions which are having raised grounds, these are self-answered.
Sure.
Lordship, one judgment, Lordship.
And that Delhi High Court, my lord, 3 judgments are there. By following the Bokaro Steel, my lord, the same issue has been decided.
They have relied upon Bongaigaon
Yes,
refinery.
Bagaigao had been, my lord,
3, Lordship.
Bagaigao had been also been Bokaro, you'll also find 3 judgments of earlier have been distinguished. by the ground, my lord, that it was after the commencement of the production and prior to commencement of the production.
Right,
If it is
right.
prior to commencement of production, then it is capital receipt.
Capital
After
receipt.
commencement of production, my lord,
Then it is
will be
taxable.
receipt.
That's
So
taxable.
those decisions will not be applicable. And the Delhi High Court also, my lord, two decisions are there.
Let's see.
Yes.
These questions of law and page.
He is given it. The basic issue is borrowed capital. Borrowed capital is not. Mr. KL,
Lordship.
your questions of law nowhere deal with borrowed capital. And receipts, pre-completion of the project, receipts post-completion of the project. That is the crucial question in this case. There is no substantial question on that issue, which the tribunal has precisely decided. Why the appeal should be admitted then.
Tribunal came to the conclusion, my lord, this is pre-commencement of the production. And
Yes.
that finding is not at all in challenge.
If Lordship finds Lordship can frame.
Why should we? Why should we? That finding is unassailable. You know, the fact that earlier also, tribunal in the case of SSC has held so, which finding is not challenged by you in this appeal.
Lordship, the entire judgment has been put under challenge.
Yes, the earlier judgment in the case of SSC, tribunal is bound by that. You are not said anywhere what is the fate of that
There is no appeal of the
Judgment.
finding, my lord.
statement of the Learned Chain Council.
There is
No appeal
appeal.
filed.
That I'm not. aware of.
We don't find any substantial question at all.
If Lordship thinks some other question is required to be framed, Lordship.
We don't think it's your proposition. We find that these are not substantial questions, which as a matter of fact need deliberation, these appeals.
Well, lordship can reframe the question, but only when, my lord, the facts have been challenged.
Make out a substantial question.
But when the facts.
Are you able to come out on the simple argument? Pre-completion of the project, post-completion of the project. That is the crucial test in Bokaro Steel. On that, there is no challenge by you on facts. Why empty formality of admitting the appeal? Why should we indulge in that?
So many appeals are pending, my lord, they still.
Is there a straitjacket formula that appeal, if filed, must be admitted?
But that cannot be.
And Delhi High Court, my lord, has also in the same way, that the no substantial question of law arises on the same issue, my lord.
Hmm. Inextricably linked with the setting up of the
That
plan.
is the-
That finding you are not challenged. There's nothing. Arguments heard, order reserved.
All the four appeals, my lord, similar, same.
That is my learned senior friend has taken a position. The assessment here, less than 12. So I am dealing, also definitely I'm dealing, but letting since he is already angry, I don't have any reservation. And the other three are two items are basically assessment here.
Same, different assessment here, same.
The different assessment here.
Same finding.
Same common judgment.
Give up synopsis, please.
Yes.
Brief synopsis.
Yes, I'm obliged, my lord.
The number 39 of supplementary list for motion.
Is admission?
Motion.
Okay, yes.
May I please your lordship? Lordship, my lord, here, my lord. The petitioners, there are two petitioners, mother and the daughter. Petitioner and the defendant number 5. They three are the family members, my lord. They are the co-partner of a land. Here what happened was that the respondent number 4 has issued a cash credit loan in the name of defendant number 5. And in which the petitioners were unaware about it. When it came to the knowledge, they filed a petition before the Honorable Civil Judge. As it was not maintainable, it was rejected. They have filed an application before the respondent number 1.
DRT,
No, they have filed an application to intimate everything to the respondent bank.
right.
On 10/1/2023, Annexa 4, page 31.
Yes.
Then thereafter, my lord, section 13(4) notice was issued to the son of the petitioner, my lord, defendant number 5. And as the
Let them till DRT.
Till the, that's right.
What is it?
DRT is not available now.
My lord,
No,
my lord, I have
This week, my lord, the presiding officer, at least till tomorrow, is not available.
page 41 is the order.
Protect them till the DRT commences its sittings.
Sorry, my lord.
We protect them till the DRT commences its
My
sittings.
My lord,
What do you say?
difficulty is that the auction is day after tomorrow, my lord.
So supposing the DRT was sitting
Lordship.
and the interference was made, what would have happened?
My lord, the most that the DRT does is that the confirmation of the auction, confirmation of sale is stayed, and
Yes.
some amount is directed to be deposited as a pre-deposit. my lord. Generally 25%, I must admit that generally it is 25%. If they make a similar deposit, my lord,
My lord.
What do you
here,
say?
My lord, here in the petition before the DRT, in the application and even before this honorable court, my lord, the petitioners are not the, petitioner and the defendant number 5 were the co-pattadars of the land. And it came to the Jamabundi in the year 2020 in the name.
Madam, for approaching the DRT,
Uh,
pre-deposit would have to be made.
My lord, that was as we are being third party, agreed party, we have made an of 6,000, we have already filed as 6,000 as court fee. We are
6,000
the
is not.
we are the agreed party as per my lord the provision. We are not the, my lord, as
They
per
are
the
not the
provisions of the
borrowers.
DRT. We are,
You must be the guarantors.
my lord,
No,
that,
no.
no,
I'm
my
not
lord.
guaranteed. They are, my lord, what has happened is that they are denying the
Owners.
that they were party to the equitable mortgage. my lord. They are
Okay.
saying that we did not deposit any mortgage deed.
Mortgage
But in
deed,
equitable mortgage, there is no question of, my lord, the mortgage deed at all.
naturally.
My lord, the interesting part is this, they admit in this petition also that in December 2022, they came to know that their son, the son of petitioner number 1, respond number 5 herein, he informed them that there is a surface proceeding. No, my lord, will the title deeds go from the house to the bank by itself? My lord, their respond number 5 is hand in glove. my lord.
Yes.
My lord, here, it
That's
is.
just a means to avoid the proceedings.
Yes.
No, my lord, here, even we have made an application before when it was before the civil judge and even before the DRT for the FSL of the of a handwriting and moreover, my
That's-
lord, on the day,
That can't be subject matter of writ proceedings.
my lord, on,
You make the pre-deposit,
my lord,
then we don't, then only will
my
protect-
lord, here,
protect you.
one more submission, my lord.
Yes.
With due respect, my lord, on the day when the press credit loan was deposited in the account of defendant number 5, the land was in the name of my late husband. It was not even transferred in the Jamabundi in my name also. That also I have annexed as in petition. There's high.
What do you say?
I have 2 affidavits, my lord, executed by them, submit to the bank, confirming that they have no objection to the creation of equitable mortgage. This is a
Affidavits by the petitioners.
yes, my lord.
My lord,
And I'll
my
file
lord,
them
here-
for the day.
my lord, the whole case of the petitioner's life, they were not at all ever, even the bank.
They have given affidavits, madam.
My lord, that was not, my lord, since it is not in read proceeding.
Make
I
a
never, my lord.
pre-deposit, then we protect your client's interest.
My
That's
lord,
the only
my
way.
lord, my only submit petitioner number 1 is a widow and petitioner number 2 is a HS student, my lord. And they are, this is the only.
This
house
is
I will
just creating hurdles in the way of the bank.
take. My
Your
lord,
son mortgages the property. This is happening everywhere. This is collusive proceedings.
on the day of, my lord, that with due respect, on the day of when the bank.
Let's see the
proceeded-
affidavits. Then we'll just dismiss your writ petition on this ground only.
No, my lord. My lord, may kindly see the Jamabundi in which our names were recorded the date.
Then why did you file the affidavit? You could have said, till date, property is not in my
My
name.
lord, that-
But Miss
my lord,
Counsel,
my-
was the bank not required to verify the title deeds before keeping them as a mortgage?
My lord, title deeds were in the name of the husband of petitioner number 1, father of respond number 3.
So,
And my lord, the
so how could that have been taken as a mortgage
because
without the signatures of the landholder?
no, my lord, they have given, they have no objection by way of these 2 affidavits, my lord.
Irrespective of that,
Lordship.
till the property devolves
Yes, ma'am.
through an entry in the record, land revenue record,
Lordship.
how can it be mortgaged
My lord, what
on the
has,
basis of affidavits?
what has happened is that they are the legal heirs. Admittedly, they are legal heirs, my lord.
There may be few more, who knows?
My lord, whether the succession or etc. was produced or not, that I have to take instructions. But these 2 affidavits along with, my lord, the deposit of title deeds. And their names came in 2020. These affidavits are of 2019. my lord. And they have 5 other accounts also.
After,
The respond number 5
5.
has 5 other accounts also. The entire list is here, my lord. In fact,
Yes, this
4 other-
declaration is joint,
Yes, my lord.
first one.
And
This is just collusive proceedings, madam.
they have not filed any FIR, etc. against the respondent number 5, my lord. No, and they are
Nothing.
same address, my lord.
Yes. Either you make the pre-deposit or else we
Pre-deposit finance at least
25%.
25%. It will be 28 lakhs pre-deposit, 20 not at all possible, my lord.
Then all right,
My
then
lord,
no remedy
my lord,
in its jurisdiction, sorry. Ask your clients,
my lord.
come back after a while.
My lord, I have already taken instruction with that aspect. My lord, it is not possible that to be fair.
Then well, let the land be
My lord,
auctioned.
because my lord, in the petition.
This is not the only account, there are 5 accounts.
My lord, everything was done by
submit before
defendant
the
number
DRT
5.
as and when it is available, because all these issues about giving a joint affidavit, you have not raised any objection.
My lord, this was not done by me. We have stated.
But have you filed any FIR saying that this is forgery?
Immediately after my lord, the FIR was not done on their
Then?
part. The issue, my lord, was open to my lord, we have immediately filed before the civil court for the FSL, but since it is not maintainable.
I could have filed a FIR.
My lord, that being.
There's no
100
question
years
of filing, he is your son.
That is the reason being.
That
100
is the
years
collusive
of time.
proceedings,
My lord.
writ large on the face of the record.
My lord, then let me, my lord, 25%, it will be, my lord, very fair submission.
There is no other way, madam. That is what statute requires. We'll just dismiss the writ petition saying
No.
disputed questions of facts.
My lord, with due respect, my lord, in a similar proceeding, my lord, of this honorable court, with regard to my lord, with regard to this honorable court only, my lord, with similar case, my lord, when the
This
presiding
court,
officer.
in large number of petitions have been dismissed
Yes,
on
my-
ground of statutory remedy.
my-
Don't tell us what this court has done or has been doing.
My lord, that, my lord, in one
All right, then
particular.
dismissed.
No, my lord,
Thank
may
you.
kindly consider, my lord, let me take, if they can, my lord, but I'm certain they can, but let me take construction.
Irrespective, we pass an order that if you make the pre-deposit, then
My lord,
your property will be protected for next 15 days.
my
that's
lord,
it.
still sitting, my lord, 25%, can it be less, my lord?
Can't be. What is the statutory requirement?
My lord, I'll take instructions, my lord, can the matter be taken up to some while, my lord?
Oh, yes.
Must oblige, my lord.
We can pass the order and dispose it of, subject to payment.
Madam, we'll pass the order.
We'll pass.
We'll dispose it of. Your client is able to deposit, well and good.
Yes,
If not,
my lord,
it's okay.
my lord.
Heard. Ms. So-and-so, learned counsel for the petitioner, Mr. So-and-so for the respondent by. This petition has been filed by the petitioner challenging the option proposed to be auction of the land in question proposed to be undertaken by the concerned bank for default in payment of the loans which were taken by the respondent number 5. It is submitted that the respondent number 5 is the son of the petitioner number 1. And petitioners 1 and 2 and respondent number 5 are the co-owners of the land in question. The petitioners submit that the land has been given in mortgage, equitable mortgage to the bank at the time of taking a loan, which fact was not disclosed to the petitioner number 1 and 2. Also, upon being aware, they have approached their DRT by filing necessary applications. Full stop. Learned counsel for the petitioner submits that the application is pending before the DRT. However, the presiding officer in the DRT is not available at present, and the auction is scheduled to be undertaken by the bank on 24th March 2023. Accordingly, the petitioner has approached this court seeking urgent orders for stay of the auction proceedings. Para. Mr. Ganguly, learned counsel for the bank, has submitted that the petitioners are indeed aware of the equitable mortgage in view of a joint affidavit which was signed by petitioners 1, 2, and the respondent number 5. Also, under the circumstances, the contention of the petitioner that they were unaware of the equitable mortgage is belied by the affidavits which are filed before this court, which are presented before this court. Also, be that as it may, since the petitioner has approached the DRT, we direct the petitioner to deposit the statutory, to make the statutory deposit.
Sorry, Manoj, it's not a statutory deposit. Manoj. Statutory deposit comes in appeal, Manoj, under section
Ah.
18.
This is
Generally,
application.
as a condition
Application.
For staying the confirmation of sales, DRT imposes a general condition.
My lord, my lord, the part I have flag mark is as per the provision of the
That is for appeal. That is for appeal.
application and.
You are in a miscellaneous application.
We dispose of this writ petition with the direction that the petitioner will deposit 25% of the amount of loan. What is that loan? Term loan.
Lordship will kindly say as per the demand notice, Manoj.
As per demand notice dated
2/8/2022. Manoj.
2/8/2022.
Yes.
Upon within
3 days.
within 3 days from today and thereafter. Within 3 days from today, and pursuant to which the demand notice dated so and so shall remain stayed for 15 days.
Auction.
Auction proceedings and the auction proceedings will be stayed for 15 days.
Auction. Sale will not.
Confirmation of the sale may be stayed.
Sale will not be confirmed. Sale will not be confirmed. What party? Because moment they fail, at least the proceeding.
It is directed that the auction will proceed but the sale certificate shall not be confirmed. Full stop. If the petitioner is unable to, this interim order, this order will be effective only upon deposit of the amount as directed by the petitioner. Writ petition is accordingly deposited
Amount may be deposited with the bank.
with the bank.
No, lordships have said sale certificate will not be, lordship may kindly say sale will not be considered, because otherwise if I issue sale certificate, third party interest will be created.
Sale shall not be confirmed.
Sale should not.
Disposal.
Item numbers 5 to 10 of daily list.
What's if item number 6 may be taken up, Lord.
My lord, first, before starting my understand submission,
Yes.
item number 10, it should be delisted, my lord, from dealing from the, because it is a department. 10 will be not.
Lordship, all the cases are of.
No, my lord, that I have want to submit.
Yes.
Okay. 50 lakhs.
1
crore.
1 crore.
1 crore, now it is 1 crore.
Perhaps Mr. Kale would like to have a look at this judgment.
Lordship, here in all the cases, one law point is there. Lordship, this honorable court passed in a division bench that the interest is applicable in case of exemption notification. So that judgment is there.
Mr. Kale, give it to Mr. Kale. Give it to Mr. Kale. Less than 1 crore. What do you say about the amounts less than?
Lordship, here, and my humble submission, is a law point is involved where section 11B is applicable in case of exemption notification or not. This honorable court in division bench held that it is applicable. Thereafter, we approached the honorable Supreme Court. Supreme Court dismissed our SLP on the ground of delay. However, question of law was kept open.
Yes.
Therefore, in another case,
We'll protect your rights so far as question of law is concerned.
no, Lordship, another submission. Yeah, thereafter, in one case, the SLP is still pending, Lordship.
Mano, this has been similar matter. Similar matter has been disposed of by this division bench, where my learned friends withdraw the application. And this one of support said, well, the decision or whatever is there of the apex court will be applicable.
Lordship, page 74 of my appeal, Lordship.
Which appeal? 5 number. Item number 5.
Item number 6.
6.
Item number 5, my lord, it relates to shifting of the garbage yard at
No. Unnecessary.
No.
There's a bunch of
This
appeals.
is a bunch of appeal, same question of law is involved. in
Also,
all
we
the
see
cases.
the last paragraph, Milord.
Change should must be.
666.
One paragraph. Lordship, page 74, Lordship.
Just hold on.
It says, Milord, the contents of revenue, this 11B of the Central Excise Act not applicable in present case. It is delay refund of certain exemptions will not be covered by so and so. But at the same time, Mr. Cal so and so very clearly submitted. The matter is entirely covered by division bench judgment of which for the related SLP have been filed in the code which is presently pending. He therefore submitted that he may be allowed to withdraw the writ appeal subject to the decision of the SLP. Thereafter, my lord saying that the writ
No, that
appeal
is,
is
I am
dismissed.
not denying that. Lordship.
The writ
Then-
appeal is dismissed and withdrawn, subject to the aforesaid condition. The revenue shall pay the amount of interest. However, the interest payable shall be subject to the outcome of the SLP pending before the apex court. Same thing, my lord.
Then what has happened to the SLP?
This is
It is
pending, my lord.
Still pending.
Pending, Lordship.
And
Same order we can pass.
74.
And lordship, see, my lord,
Lordship,
when it's a question of law open, question of law is open before the Supreme Court. My lord, it's not so that the High Court decision is the High Court will follow it. If the matter goes again to the Supreme Court, then the question of law will remain open before the Supreme Court. And
Unless,
because the- and the
unless they
review
want to
commission, which was-
distinguish.
And the lordship, my lord, Justice Saiki also, my lord, dealt with a single bench, and against which this appeal was filed. And the appeal was withdrawn by my friend.
They can raise this question of law. if they want.
Lordship,
Even in any other matter,
No,
in
Lordship,
this court even,
no,
we are not foreclosing your right to argue the question of law.
No, Lordship, actually, that was a writ appeal. Here, these are the appeal against the CSET's order, Lordship.
Yes.
No, item number 5 to.
My item is a writ appeal, my lord.
It is, item number 5 is writ appeal, others are appeal against the CSET, Lord.
Yes.
But the issue is this.
Issue is same. Then
Issue is same, and my contention is that our another SLP is pending, Lordship.
irrespective thereof,
That has been taken note of by the division bench, my lord. The SLP is pending.
what do you say about this notification 2 crore limit?
That is there, Lordship.
So
But
then-
when, Lordship, there is an exception to this notification also.
Where is it?
Probably paragraph 6
Of,
of this notification, Lordship.
there are no 6 paras. It ends at para 5.
I'll protect Lordship. Because the option is open to the authority to take this. And if there is an audit objection,
Read the notification, please.
When one question is decided in question 5, the others will also,
it will follow.
irrespective of the imitation.
Thereafter 20 notification is also there, Lordship.
There are questions of law.
Hmm.
And in fact, the my lord, submission is that, my lord,
Mandatory limit.
there is a country circular of the board.
Hmm.
Well, that was also considered by the division bench, that the board circular cannot, my lord, override the statutory provisions, and the judgment, my lord, the review was dismissed also by this one of the court.
No, that we are not disputing because
That is ground taken.
I was the,
That is the ground taken in appeal, my lord, that the board circular is there. The same ground which. was-
Board circular also carves out an exception, para 4, where a substantial question of law is involved. The department can contest.
Certainly, my lord, but when I'm repeating, not my case, not when as item number 5,
Hmm.
same issue is the question was decided by the lawsuit, saying that, my lord, the question of law is be covered by division bench. All others, my lord, also.
and Lordship, with regard to this monetary limit, there is a subsequent notification also. There is a clause 6 where 3 exceptions.
In
are
this
given.
one, there is a clause 4.
It is.
Read clause
It
4.
will be noted that the involving substantial question of law as prescribed in para 1.3 of instruction of 17/8/2011.
But when the matter is covered by division bench, where the prescriptions which are lost.
KL, you yourself made a statement in this court,
Lordship,
issue covered by division bench judgment. Then why are we required to take a different view and admit the appeals as a matter of formality? We'll cover the judgment by the said judgment to carry these cases to Supreme Court.
Lordship, that will,
That you can do.
that will.
There be some matters in the Supreme Court also, why all in the High Court, my lord.
But there is a appeal pending. There's an SLP pending also.
That's
Yes,
what is
Lordship.
referred.
And other matter, my lord.
Page 74, Lord.
74,
Lordship of my appeal, item number 7, Lord.
7.
Lordship, these are the copy, Lord.
That is mentioned in the division bench order also, my lord, the SLP number also.
Lordship, these are the copy of the,
And that you have mentioned,
yes, Lordship.
Union of India, Dharampal Satyapal.
Yes,
My
Lord.
lord.
Yes. Rather, you have withdrawn the appeals.
It will create difficulty for me.
You have earlier,
Lordship,
you have withdrawn
yes.
the appeal. Then
Lordship, in this case, Lordship, at the observation of the Honorable Court, Lordship, I made this submission.
what observation?
Regarding, because since this Honorable Court has already decided the point that section 11B is be applicable in case of exemption notification.
Mhm.
And since the appeal is pending before the Supreme Court.
But it is mentioned it is fairly submitted by Mr. Kyal. So he should today also fairly submit below.
No, I am not unfair to anybody, Lordship.
No, there's no question. There's no question to that. There's no prayer for entry. So for empty formality, we may admit the appeals, make the payment.
Lordship, may pass the necessary order. We'll-
Is there a prayer for interim relief? No.
Lordship, separate application was filed in item number 6 and 7. Six,
In
seven.
item number 5, we don't see any application.
No, Lordship, this is the writ appeal against the order of the Honorable Single Judge.
Yes,
There is no separate application.
even in item number 6, there's no,
Separate application has been filed.
when? It's not listed today at least.
Attention, item of 5 million, saying there is no interim application.
5,
5, there is no interim.
6,
Lordship, no.
6, there is an IA. 5 also there is an IA. It's shown. IA civil 1607.
That was continuation of delay, Miller.
Okay. That's what we are talking about. Stay application. There is already stay by this court,
Yes, Lordship, in item number 6 and 7.
6 and 7.
And in fact, Miller, this Honorable Court directed Miller that the whatever judgment will be there, that we will, so the question will not keeping it pending here.
You will get a reimbursement in
No,
case you succeed.
That is the Lordship.
So make the payment.
No, Lordship, we have to follow the
Follow what?
earlier order, Lordship, regarding if the appeal is dismissed, then it will be all the payment will be subject to the outcome of the.
That is mentioned there.
That's mentioned in this earlier order.
Lordship, difficulty before the department was that Lordship, CSET passed the order, Lordship,
Hmm.
and we have no option but to approach this Honorable Court.
Item 6, there is a stay.
Yes, there is a stay. But what is the impact of this direction? Revenue shall pay the amount within a period of 3 months. However, the interest payable shall be subject to the outcome of the aforesaid SLP.
So that in case the SLP is decided in favor.
Then you will
Then we have to-
reimburse
We have to reimburse.
refund the interest.
Lordship.
We can pass the same order,
Lordship.
admitting your appeals
Lordship,
and directing you to make the payment.
Lordship.
And of course, they would be required to give an undertaking
Sir,
that they would refund the interest amount in case of, as per the decision. of
Lordship, that way.
So far, it appeal is concerned.
Solvent certificate.
Well, so far, it appeal is concerned.
Even undertakings. Yes,
The writ appeal concern is not disposed of in the similar line, Miller, keeping pending, Miller. This is not restricted to appeal.
that
Because
is all right, but the question of law is same.
So the question of law is same, but writ appeal earlier was withdrawn. So there is no use of Miller keeping it pending, Miller. The direction is there, undertaking will be given, that's all.
This is in relation to this very same order.
Same.
No, why writ appeal?
Writ appeal, Miller, because the direction of the only single judge was there, following the division bench judgment to pay the interest,
To pay the interest.
pay the interest.
Same issue, Lord.
Same issue, so the Miller, when the direction of this honorable court is there, that this will subject to the result of the SLB, Miller, and Lordship directing that the undertaking will be given, then there is no use of keeping it pending, Miller.
So then we can dispose of all the appeals saying
Lord.
they'll give the undertaking
Lordship,
that in case of
Lordship,
the SLP being decided in favor of the revenue,
Lordship,
the interest amount as has been paid
Yes.
will be repaid with interest. Right? We'll save the interest of the revenue also.
Lordship.
But I didn't know saying, my lord. That appeal there time bar, madam. You have not find any.
Lordship, it was kept defective in the section.
Because
There-
2 years defect when there.
If it is time barred,
Lordship, not time barred, Lordship, why the, Lordship, what happened?
After.
Lordship, what happened? There was a miscalculation by the department in calculating the days, Lordship. Because from the date of.
But that would not be a ground to condone the delay
No,
without an application.
no, there is no delay, Lordship, at all.
Let's see.
Otherwise, Lordship, why is that section?
All right, right,
listed
take down
by-
in these appeals. These appeals preferred by the revenue involve the common question of law as to whether interest is applicable, interest is payable to NSE, SSE on delayed refund of exemptions. First of, in an analogous appeal being so and so, comma, Mr. KL, Learned Counsel representing the department, submitted that the question aforesaid is pending consideration of Honorable the Supreme Court in SLP number so and so. Dr. Saraf, Senior Counsel representing the respondent in so and so, submitted that an identical appeal number so and so, that this is rate appeal number 160/21, has been disposed of by this court, subject to the condition that the interest payable to the SSE shall be subject to the outcome of the aforesaid SLP pending before the apex court. In view of the facts and circumstances noted above, comma, we dispose of these appeals requiring the department to make payment of the interest on delayed refund to the respondent SSE within a period of 1 month from today.
2 months.
2 months from today. However, the SSE shall furnish an undertaking that in case the revenue succeeds in the aforesaid SLP, comma, the interest amount paid under this order shall be reimbursed to the department with applicable interest as per law.
Is subject to the words will not with applicable interest will not be given because that will be interpretation will not let us again will not be.
All right, reimbursed to the department.
My lord. I'm obliged, my lord.
Now item number 10. All, what else? What is the problem?
No, I know.
Okay, all dispose of.
Lots,
Everything, all dispose of.
lots.
These are till 10. Of course. Attendance, mark it accordingly. Otherwise, their bill of fees will not be honored. Okay.
Letter number 11.
But one deduction was in my case saying that I filed a petition also. Then we need to they have to watch us. That is matter the civil order is one that we need to dispose of account as per law.
Single bench. To cite this order, they will dispose it of. Why do we dispose of the matters pending before single bench?
May I please, your lordship? Lordship, the counsel for the respondent number 1 is in bereavement, my lord.
Is
in bereavement, my lord. Someone in his family members have expired, my lord. Can be taken up, my lord, next week.
all right. As prayed by learned counsel for the respondent.
No, number 1.
List. Respond number 1. List of 4 weeks.
Obliged.
Letter number 12 and 13.
Yes,
I believe I'm appearing on item number 12, my lord.
yes.
My lord, is relating to the my lord entitlement of pension, my lord. The appellant.
Yes.
Thank you.
Non-providence of pension. Strange.
May I please, your lordship, my lord, in item number 13, I am led by senior counsel, Mr. K. N. Chaudhary, my lord. But today he is having some difficulty, my lord. He's gone for the funeral of the senior counsel, Mr. DC Mohata, my lord. So may I pray that this matter may be passable for the day.
List of 2 weeks as prayed. By learned
Alright.
counsel for the appellant. Review.
Review.
Letter number 14 with item number 41.
May I pray, your lordship, the matter may be taken after some time. After some time, your lord.
Contractual matter.
Yes, your
My
lord.
lord, they have filed an application. It's basically a rehearing of the same thing they are saying. They could not allege any malafide. And my lord, the sufficiency and adequacy of a contractual matter
cannot be looked into under judicial review because they want to challenge the decision, not the
Yes.
decision-making process.
Yes.
So I pray that this, in fact, personally, nothing new has come in. They wanted rehearing of the same matter.
Right.
So I pray that since the Tata Cellular and Mandal's case is very clear, especially paragraph 22, the
Yes.
judicial review cannot take the place, well, para 22, if I may read.
Yeah, Lordship.
Why are you trying to undertake the same exercise twice over?
Yes.
Why you are trying to do that? He is saying that pass it over,
Your Lordship.
pass over.
For the time being, Your Lordship.
Yes, yes.
Matter number 15.
May it please your lordship.
Yes.
Lordship, by the last order, I was directed to file an affidavit indicating the annual income of the respondent. Now, my lord, this direction was issued in light of the fact that this honorable court had indicated that the respondent appears not to be eligible for legal aid services because
Yes.
he's a contractor.
Yeah.
Now, my lord, and the secretary of DLSA Bongaigaon was directed to provide assistance to me so that I can get in touch with the respondent. So immediately the phone number was provided to me. I spoke to the respondent and I asked him to provide me with the ITR of the past 3 years so that the same can be brought on record by way of an affidavit.
Right.
But my lord, since more than a month, he has neither contacted me nor has he
Mr.
provided
Roy,
me the details.
Ms. Counsel, see the notice to the respondent was issued on the application under section 5. So let notice of the appeal go.
Lordship, let it.
You will discharge you from your obligation.
Lordship.
Ms. Pooja Agarwal, learned amicus curiae, legal aid counsel
Legal aid.
submits that the respondent is not responding to her calls. In this view of the matter, we hereby discharge MS Agarwal of her obligations to act as a legal aid counsel on behalf of the respondent, issue notice of the appropriate appeal to the respondent. Rule is made returnable in 6 weeks. Steps be taken in 7 days. Thus the service is permitted.
Deeply obliged, ma'am.
Obliged.
Matter number 16.
May I please your lordship? This is an
Yes.
appeal against the order of and judgment passed by the Landed Family Court Silchar, my lord.
Yes.
Divorce was declined, my lord. So we are before your lordship.
We'll admit
This, no,
Admit
admit-
admission notice. Lower court record be called.
Step by registered post, my lord.
Not registered post.
Registered
Right,
post.
deeply obliged.
We can give you dusty also if you want.
Obliged.
Matter number 17.
Ken Chaudhary is not here. That, have you brought that confiscation order?
Yes, Lordship, that is there.
Can we see it?
So this, in fact, Lordship, there was a proceeding happened before the High Court Committee. And this petitioner was present before the committee.
Let's see.
And copy was served to him also as per this order,
That order is not under challenge.
not under. It was not under challenge. And they did not
Chapter closed.
neither modified the.
You
prayers.
didn't bring it on record anywhere.
Oh, I'll do that, Lordship.
I know, but why not? During the writ, why this order was not brought on record?
For that, Lordship, there was some mention about this proceedings, but this order was not brought on record.
This order makes the entire
Yes,
scenario.
yes, Lordship, that's true.
We'll pass it over. Mr. Chaudhary is here in the court or not?
Chaudhary, probably he was busy with the funeral of.
So let's have it tomorrow. Provide the copy to
I'll do
the
that.
petitioner's
I'll
counsel.
do that.
And counsel, Mr. Good name,
Kalita.
Kalita, has placed on record. Copy of the order dated 30th April 2020, 2002 oblique 17th May 2002, whereby, the Gomari timber in question was ordered to be confiscated. It is stated that the appellant herein was present in the hearing undertaken by the High Power Committee.
So he is there in the conclusion part, Lord.
List-
His presence and all. Page 3, your lordship. It is not page nated, lordship, I'm sorry.
Yes. Is.
Number 9
Paragraph 10.
conclusion part, lordship. It will be page number 3, lordship.
Para 10,
Para 9, your lordship.
9 and 10.
Yes, 9 and 10. lordship.
The said order is taken on record and shall be incorporated in the index list tomorrow.
Lordship,
Please provide a copy
I'll do that.
to the associate counsel.
Lordship.
Item number 19.
May I please, your lordship? Your lordship, I am making an earnest prayer, your lordship. Your lordship, as regards your lordship, item number 19, your lordship, there is some technical issues, your lordship, as regards the annexure of annexing the annexures, your lordship. So I pray, your lordship, I may be allowed to rectify the same, your lordship, and
What kind of issue? Registry has not pointed out anything.
Your lordship, in the writ appeal, your lordship, the annexures are not being marked in a seriatim, your lordship. in a
All right,
seriatim.
and counsel for the plan, praise for, and is granted. 4 weeks' time?
Your lordship, the matter may be fixed on 27th of this month. your
Why?
lordship.
Why?
Your lordship, I may be.
Praise for and is granted a week's time
Yes,
to
sir.
rectify the errors in placing the annexures in the file of writ appeal. List after 1 week.
Much obliged, your lordship.
Item number 20.
Lordship, I pray for passing of the matter for some time, my lord. My senior, he's at legs, my lord.
Pass over.
Item number 40 of supplementary list for admission.
May I please, Ajay?
Yes, please.
My lord, the order of the learned single judge, my lord, it starts at page 221, my lord.
Yes.
My lord, the petitioners are, my lord, the madrasa stream state qualified candidates, my lord. And they intended to participate in an advertisement, my lord, which has been recently floated in on 27/12/2022, my lord. My lord, in that advertisement, the Arabic category post had also been advertised. My lord, but the difficulty is that in the, my lord, may kindly turn to page 162, my lord.
Yes.
My lord, in page 162, in conditions of the recruitment, in clause 2, my lord.
162.
My lord.
Right.
Yes, my lord, in clause 62, I am referring, my lord. Clause 2, my lord.
Yes.
The applicant should have appeared and passed the higher secondary teachers eligibility test in the concerned cadre conducted by the government, scoring a minimum of 60% mark in case of the unreserved category candidate and minimum of 55% marks in case of the scheduled caste and the scheduled tribes and other backward class persons with disabilities candidates. Now, my lord, the difficulty which arises, my lord, although we are postgraduate TET qualified candidate in the madrasa stream, my lord, as there is no madrasa TET has been mentioned, my lord. So therefore, my lord, although we have applied, but the, my lord, authorities are not intending to proceed further with our applications, my lord. Therefore, my lord, we have challenged this clause before the learned.
What is the position of rules?
My lord, the
Do the rules countenance for madrasa TET qualified candidates to apply for these posts?
My lord, in the earlier time, my lord, the state government has allowed the madrasa TET qualified candidate.
So
also.
the simple question is,
My lord.
what is the position of rules?
My lord, the question of rules.
Rules, position of rules.
Position of rules is very clear, my lord, that the 2018 rules, my lord, there is no TET or the general TET or the Assam TET has been mentioned. It is only TET has been mentioned there.
Okay.
So therefore, my lord, when we, my lord, approach before the learned single judge that we are intending to, my lord, participate in the Arabic category post, my lord may be pleased to find the number of posts which they have advertised from the, my lord, at page my lord, 168, my lord.
168.
168, Arabic category, my lord. We are from the Karimganj district, my lord, and that Karimganj district, my lord, may be pleased to find at page, my lord.
Four posts are there.
4 posts are there, my lord.
Right.
So only, my lord, in the entire state, my lord, all the categories of Arabic teachers posts are there as per my instruction, my lord. Only 3 candidates, my lord, is available with the eligibility, with the eligible qualified candidates who can apply. Now, my lord, as we fall in the category having the specialized in Arabic stream, my lord, so we are the best suitable persons to be accommodated in that post. Now, my lord, only difficulty is that as we passed out our stream from the, my lord, Madrasa TET examination as an category and in the lecturer category, my lord. Therefore, the authorities are not inclined, my lord, to give us the benefit of this advertisement.
Okay. Where are the rules? Can you read the rules?
Lord,
Please, all right, please point out the
my lord.
reasoning in the single bench judgment.
My lord,
Why
may be-
your relief
yes,
has
yes.
been
My
denied.
lord, may I please to take up the page 100 and, my lord, the page 220, my lord, the order starts.
Is there a similar matter
My lord,
before this court? Any other matters before this court?
yes, yes, one writ petition number, writ appeal number 254 of 2022, my lord. But that is of the another learned single judge, my lord. My lordship has already heard that matter and fixed on 6th of June, my lord, of this month for hearing, my lord. That writ petition has been, appeal had been admitted. But only thing, my lord, is that as we have applied, my lord, if our application is not going to be considered, my lord, then we will miss the bus, the recruitment would be over. So, my lord, may I pray, my lord, that there are some issues connected with the earlier writ appeal also, which my lordship was pleased to admit. My lord, this writ petition can also be taken care of along with that, my lord. Only, my lord, interim protection, we are, my lord, humbly praying before my lordship is that, my lord, we may be allowed to, my lord, participate without the leave of the court, my lord, our result may not be declared, my lord. Some similarly situated persons, my lord, has earlier, my lord, appointed as an Arabic teachers, my lord, they are working, my lord.
Please read page 222,
My lord.
bottom para.
Yeah. The learned advocate general Assam, on the other hand, submit that there is a bar for the petitioner to apply for the post of the postgraduate teachers in the different provincialized secondary schools. Advertised by the advertisement dated 27/12/2022 in view of the notification dated 10/9/2020 issued by the Secondary Education Department, which provides that all notifications allowing the madrasa TET qualified candidates to apply for the post of high schools / high madrasa higher secondary school under the Secondary Education Department and LP / ME schools under the Elementary Education Department are hereby cancelled with immediate effect. My lord, this 10/9/2020 notification, my lord, is my lordship is kind enough to examining in the earlier writ appeal, my lord, 254 of 2022, my lord. So, my lord, that issue is also connected. And secondly, my lord, the learned single judge, while relied the order of the earlier, my lord, judgment, which I have also annexed in this writ appeal, my lord, starts from page, my lord, 187, my lord.
Yes.
My lord, in this page 187, my lord, one observation was there from the learned single judge in the earlier round of litigation. My lordship may be pleased to find that observation, my lord.
Yes.
Is that, my lord, page 218. May I read over, my lord, the paragraph 10, my lord?
Yes.
A stand has been taken by the learned advocate general Assam that the MTET qualified Arabic and Hindi teachers were allowed to participate in the selection process initiated by advertisement dated 11/3/2018, as there were dearth of candidates. The same position was also clarified by the notification dated 3/11/2018. Subsequent to the issuance of the impugned notification dated 5/1/2019, another notification dated 8/3/2019 was issued, further clarifying that the MTET FM pre-senior and MTET Hindi were treated to be qualified for the Arabic and Hindi teachers in ME schools. Therefore, this court is not interfering with the such decision not being under challenge. My lord, what has happened, my lord? Earlier, my lord, as I have already humbly submitted, my lord, that the state government has decided to give appointment to those persons who has an Arabic qualification with MTET, they can go for their recruitment drive in the general schools, my lord. Some persons are still working. It is an admitted position. Now, my lord, once this 10/9/2020 notification came, my lord, the entire set of earlier notifications allowing the madrasa TET of the Hindi, Arabic, as well as the general course curriculum, entire set has been cancelled. So that was the situation on the day of delivery of the judgment, my lord. So this judgment is also under, my lord, examination before my lordship, my lord, in
That writ
250
appeal.
my lord, my lord.
But
So, my lord,
is there any interim order passed in this appeal? There's no.
no,
interim.
no, my lord, only only it has been admitted.
Oh.
Because, my lord, in those cases, the recruitment process was already over long back, my lord. So therefore, there is no my lord, benefit will give the interim order. But in my case, if my lordship is kind enough, my lord, to at least our applications may be scrutinized. And my lord,
Originally, was the notification. That civil court order can continue.
Right.
We can qualify it only for Arabic. But would you be claiming only against the teachers Arabic?
Arabic, my lord, no,
Only?
only Arabic, my lord, only Arabic.
What do you say?
But the verification process has already been over, my lord.
Still,
Verification of application has already been over, my lord.
you can verify it. How many applications
No,
are there?
our application has also been verified. My instruction is that, but they are not proceeding.
We'll
further.
provisionally allow them
My lord.
for only for the Arabic post
Oh,
because that notification and the single bench order is already under scrutiny.
My
Yes,
lord.
that is there.
We'll provisionally allow them.
Yes, my lord.
Okay.
Heard
Yes.
learned counsels for the parties. Admit. Learned counsel, you appear for all respondents?
My lord.
You appear for
I am for my lord. Okay.
all the respondents.
My lord.
Since
All
learned,
the responsible.
since learned counsel, Mr. So-and-so appears for all the respondents. Notices are waived. However, extra copies be furnished within 3 working days. The learned
My lord, I'll serve.
counsel. Meanwhile, the petitioners be permitted to participate in the selection process
Initiated by advertisement dated 27/12/2022
initiated by advertisement dated 27/12/2022
for the post of postgraduate
for the
teacher
posts
Arabic. My lord.
of postgraduate teachers Arabic
My lord, the Karimganj district.
in the Karimganj district.
My lord.
Full stop. However, no final orders be passed in respect of the appellants without leave of the court.
My lord.
We'll see.
List this appeal along with
254 of 2022.
writ appeal 254 of 2022.
My lord, highly obliged. Highly
Like
obliged.
like this, the petitioner shall be, appellant shall be provisionally allowed to participate
My lord.
without creating any equity in their favor. The result shall be kept in a seal cover.
My lord. Obliged, my lord. Highly obliged.
Item number 42 of supplementary list 1.
One more supplement.
Second round. Mayor, please, my lord.
Yes.
My lord, the APGCL is before your lordship. A pursuant to a judgment of the Honorable Supreme Single Judge, wherein, my lord, the petitioner had prayed that he, having retired on the last day of March 31/3/2016, he would be eligible to get the revision of pay, which came into effect from 1/4/2016. 17, sorry, madam, which came into effect from 1/4/2017 and 16, 1/4/2016, madam. What had happened was, madam, the pension, he was a pensioner already, and, my lord, his pensions were being granted under the old scheme. When the new scheme came, we revised his pension as per clause 32 of that. But he claims that he requires to be considered as an existing employee on 1/4/2016 because he becomes a pensioner on that day, and he will be entitled to the revision, and accordingly his pension has to be revised, which we, my lord, contested. If I may have my lord's attention to the relevant page 51, my lord. This is superannuation order, my lord.
Yes.
My lord, in pursuance to letter
No,
number
no, that date is not in dispute. The
They-
date is not in
Not in dispute, my lord.
Yes,
And his pension and pensionary benefits were settled on that day itself, 31/8/2016, next page.
Right.
Now, my lord, the memorandum, my lord, would find at page 53. The office memorandum by which the revision was brought into play.
yes.
My lord, memorandum clause 1, Roman 2, my lord. They shall be deemed to have come into force on 1/4/2016 in the interim. And my lord, the relevant is page 54, clause 4A. All employees who were in service on 31/3/2016 or who may have been appointed on or after 1/4/2016 shall draw pay in the revised pay structure applicable to the post grades for which they have been holding or to which they have been appointed, as the case may be.
Service on 31st March.
March
So he
2016.
retired at 5 o'clock on 31,
On-
31st.
So he was not there, my lord, on,
How can you say?
my lord, will come to the next paragraph.
Yes.
Clause B, my lord.
Yes,
Provided that an employee who was in service on 31st March 2016
yes.
may at his her option continue to draw in the existing pay band grade pay until the date on which he or she earns his her next or subsequent increment in the existing pay band and grade pay, or until she vacates his her post or ceases to draw pay in the existing pay band and grade pay. So, my lord, it means employees who were there on 31/3/2016 and who have crossed over and continued to be an employee on 1/4/2016. The petitioner, my lord, ceased to be an employee.
That is nowhere the indication in this OM, Mr. Counsel.
My lord, because my lord would see, otherwise it does not make a meaning. My lord will have to read 4A and 4B together. If my lord reads 4A and 4B together, all employees who were in service on 31/3/2016,
Yes.
it means, my lord, it defines the employees or
Yes.
who may have been appointed on or after 1/4/2016.
Or,
Or.
That is or.
Or, my lord, or. It
So,
covers both.
it covers-
It means, my lord, any person who was there on service in 31st of March 2016
yes.
and continued to be in service on 1/4. Otherwise, my lord, because my lord would see,
You
Or-
can't read.
or-
no, no,
And in
my lord,
place-
I'm trying to make, my lord,
Yes.
the revision comes into effect on 1/4/2016. So, my lord, we will have to deem that he was an employee, master servant relation continued as of 1/4/2016, my lord. Otherwise, my lord, if the revisions come into force from 1/4/2016, my lord, the person is not there. He becomes 61
Maybe.
on that day,
By this order,
lordship.
you have also taken in the ambit of this scheme, those who were still in service till 31st March.
My lord, whoever were there in service till 31st March and my lord continued.
No, and we don't read anywhere.
My lord, the same provisions are there in our Assam service rules, pension rules, my lord. In the Assam service, seventh review recommendation,
Yes,
all those employees who were retired on 31/3/2016, my lord, where that basic pay was calculated and they were paid. And that, my lord, would find the indication, my lord, at page 61 and 63, because we made a specific query from the AG, my lord, on that.
yes,
My lord would have page 63, my lord.
yes.
Second paragraph, my lord, 63.
Hmm.
Moreover, with reference to the clarification sought by you in the letter under reference, I am to state that fixation of pension and other benefits in respect of government employees of the government of Assam who retired on 31/3/2016 are being settled with reference to the pay admissible to them on 31/3/2016 under the revision of pay rules 2010. That means the revision of pay rules earlier. Because, my lord, why this is being done? On 31/3/2016 at 12 o'clock, my lord, he crosses the age of 60 years. In terms of the regulation, my lord, I'm backed by a judgment also of the of the Delhi High Court on that. Same covered case. Wherein, my lord, on from 1/4/2016, he attains the age of, he starts 61. So, my lord, on 1/4/2016, we don't have a master servant relationship. If we don't have a master servant relationship.
You mentioned he was in the office till
Lordship.
5 o'clock.
5 o'clock.
Presumably.
He,
Any
my lord,
order
will hold
passed
it that he
just-
was there till 12 o'clock.
Just 12 p in the night.
Night.
Right. Any order passed by him during the course of that day, would it become non-est?
No, my lord, till 5 o'clock, if he has passed any order, it would be
Then
appropriate.
he was having that master servant relationship On
on
31st.
31/3.
Yes. So
Lordship, no doubt about it.
then your OM,
But my lord, we brought this into operation. The revisions came into operation on 1/4/2016.
you make,
He is not
make
drawing a pay on 1/4/2016, my lord. That's my case.
you incorporate this fact that the one who was drawing pay on 31st March will also be covered.
Yes.
This is an anomaly
My
created
lord,
by
that's
you.
why. My lord,
Yes.
that is why, my lord, why I was, my lord, trying to. There is a separate provision for this category at 32, my lord. Page
Yes.
55.
2.48.
No, my lord, page 32, page 55, my lord, para 32.
2.48 factor.
2.48 factor.
Yes.
That, when we have given it to them also, my lord. Because the honorable judge, my lord, honorable single judge.
Can we have his PPO?
Yes, it's there.
Where is that? Where is it?
My lord would have page 52, the first order, my lord. On the date of his retirement, what was given, my lord?
PPO.
My lord, there is no PPO in the thing. We pass orders in this manner, my lord. Because this is not the, my lord, it's a corporation, my lord.
Okay.
My lord, we'll have page 52.
Yes.
My lord, on the date he retired, because this subsequent office memorandum came in 2017 only, my lord. My lord, we'll see 31/8/2016, he was given this.
31.3.
31/3, sorry, 31/3/2016. Pension. Rupees 24,660 per month, only with effect from 1/4/2016.
Yes. So the pension starts from 1/4/16.
16. So, my lord, that's what I'm trying to project before my lord. He will not have the pay scale revised on 1/4/2016. Because, my lord, the provisions of clause 4A is pertaining to pay scale, my lord, salary. Because his pension is there from 1/4/2016, he cannot have a salary on 1/4/2016. my lord.
He didn't require. He was in service till 31st March.
My lord,
He's trying to say.
my lord,
that-
what I'm,
No, it says the new pension starts from 1/4.
1/4.
pension will start from.
But that is a lacuna, which is.
There's a clause
It's a
4.
lacuna.
Yes.
You mean to say that the pension starts from 1/4
1/4/2016,
and he retires on 31st.
31st, my lord.
So therefore, he cannot be governed by the.
He cannot have a salary on 1/4/2016. He cannot have a revised salary on 2016. my lord.
I want revision of my last pay. What my learned friend is asking,
Yes,
my lord.
that's it. Then if, my lord, let me just test that submission, my lord. The last pay is on 31/3/2016, my lord. This office memorandum brings into operation the fact from 1/4/2016. How can the salary be revised as of 31/3/2016?
There's an anomaly in your order.
I
which has
understand, my
created-
lord. I
which has
understand.
created this difficulty.
I understand, my lord.
Yes.
But the intent, my lord, will have to read 4A and 4B together, my lord. And then 32,
Yes.
55, my lord. The pension, family pension of the existing pensioners, that is pre-1/4/2016 pensioners, family pensioners, shall be revised with effect from 1/4/2016 in the following procedure. Revised basic so and so on 1/4/2016. Revised basic pension on 1/4/2016 of the pensioners who are drawing pension, family pension on so and so shall be fixed by a multiplying the existing family pension by a factor of 2.48.
Yes.
And we gave him this. B, the revised basic pension in no case shall be lower than 50% of the sum of the minimum of the pay in the pay band and grade pay,
Yes.
thereon corresponding to the pre-revised pay scale pay band from which the petitioner had retired. This is applicable to those petitioners who had retired on or before 31/3/2016 and after completing so and so as the case may be. And my lord, interpreting, my lord, similar conditions, similar situation. My
How
lord, I
does
have
the
not
single
been able
bench,
to lay my hand on a Supreme Court judgment.
how does this single bench deal with this argument?
Lordship, the single bench, my lord, honorable single judge, my lord would come to page 99, my lord, para 10.
Yes.
Oh, my lord can straight away come to page para 15, my lord.
Yes.
101, para 15. At this stage, it is also apposite to refer to the provisions contained in 4A of the revised pay rules 2017, which pertains to application of the revised pay. Rule 4A has laid down that all employees who were in service on 31/3/2016 or who may have been appointed after 1/4/2016 shall draw pay in the revised pay structure so and so applicable to the post grades which they have been holding or to which they have been appointed.
Para
As the case-
16, what we are observing,
Lordship.
read para 16.
My lord, okay, Lordship. Para 16. In
Yes.
view of the settled position of law that the employee retires from service in the afternoon of the day of the month in which he attains the age of superannuation, and from the office order dated 31/3/2016, by which the petitioner was released from service on attaining the age of superannuation of 60 and at 5 p.m. on 31/3/2016, there is no doubt, no iota of doubt that the petitioner was in service on 31/3/2016, and he also retired from service on 31/3/2016. In other words, the petitioner was in service and had not retired from the service on and had not also retired from the service on 31/3/2016. This court is thus of the view that the petitioner had not acquired the status of pensioner on 31/3/2016 as on that day he was in service and had also retired from service on reaching the age of superannuation at 5 p.m. He had acquired the status of pensioner only from and on 1/4/2016. This view gets fortified from the office order bearing so and so, which recorded that the petitioner retired on 31/3/2016 and the petitioner was sanctioned pension rupees 24,600 per month only with effect from 1/4/2016. My lord, he gets a pension on 1/4/2016. Now, on that same very day, 1/4/2016, he cannot have a revised pay scale.
Reverse pay scale would be related to.
It cannot go back to 31/3 because the office memorandum comes into operation from effect of 1/4/2017.
Say that to apply to employees who are in service.
My lord, that has to be understood, my lord. That has to be understood with the next column, my lord, 4B. My lord, it says employ. Provided that an employee, B, my lord.
Yes.
Provided that an employee who was in service on 31/3/2016 may at his or her option continue to draw pay in the existing pay band and grade pay until the date on which
Chaudhary will admit it, there is no prayer for interim stay.
there is a prayer for interim stay, my lord. Because, my lord, we have made the,
Interim,
my lord, we have made that prayer in the,
the appeal.
Will not stay. You may-
but the only problem is, my lord, they have filed a contempt.
Of course.
We are
we'll
on the
file
fifth of a
contempt.
contempt. My lord, my lord wants me to file an
My
I.
lord will kindly clarify
Yes,
that
sir.
there is no stay, my lord, because it's a question of pensionary benefit.
No judgment, not against.
Yes,
My lord, then, my lord, I rely on a judgment of the Delhi High Court on a similar situation, my lord.
Alright.
My lord, we'll just examine how it was dealt with.
Yes. Prayer is incorporated in the appeal. Yes,
My lord, stay prayer was incorporated in the appeal, my lord.
yes, that
was-
is there. We've seen.
It's there, my lord. My lord, we'll come to para 2, my lord. The Union of India has preferred the present writ petition to assail the order of dated so and so passed by the Central Administrative Tribunal, Principal Bench, New Delhi. By impugn order, the tribunal allowed the original application preferred by the respondent and held that the applicant is deemed to have retired from service on 1/1/2016. Consequently, the tribunal held that he was entitled to get all his pensionary benefits in accordance with the 7th Central Pay Commission recommendation. The office memorandum dated so and so issued by the petitioner asserting that the respondent had retired on 31/12/2015 was quashed and set aside. And the petitioner was directed to fix the retirement benefits of the respondent in accordance with the 7th Central Pay Commission, which was implemented by OM dated 4/8/2016 in respect of pensioners retiring on or after 1/1/2016. The date of the birth of the respondent is 1/1/56. Considering the age of the retirement superannuation is 60 years, he attained the said age on 31/12/2015. As per the petitioner, the subject of retirement is governed by FR 56 in chapter 9. The said chapter deals with, my lord, can just ignore that and come to, my lord, paragraph 8, my lord.
Yes.
On the other hand, the respondent who appears in person submits that he attained the age of 60 years at 12 p.m. midnight on 31/12/2015, that is on the night of 31/12/2015 and 1/1/2016. He submits that the respondent became a retiree only on 1/1/2016. And in terms of the office memorandum dated 4/8/2016, he was entitled to be treated as a 2016 retiree. Consequently, his pension should have been fixed on the basis of the pay fixation under the 7th Central Pay Commission recommendation, which came effective from 1/1/2016. Then, my lord, then the conclusion starts from para 11. Firstly, we may observe that since the date of birth of the respondent is 1/1/56, he attained the age of 60 years, that is the age of superannuation, on 31/12/2015. The respondent appears to be reeling under the impression that he attained the age of 60 years only on 1/1/2016, which is not correct. On 1/1/16, the respondent entered the 61st year of his life, having completed 60 years on 31/12/2015. The issue of retirement in respect of central government servants is covered by 56. We have already quoted the relevant extract from the said rule. The first provision so-and-so is clearly attracted to the facts of the present case, since the date of birth of the respondent falls on the first day of the month, that is on 1/1/56. Consequently, by virtue of the first provision, the respondent retired from service on the afternoon of the last day of the preceding month on attaining the age of 60 years. In case the respondent that was afternoon of so-and-so, even if the expression afternoon is construed broadly, it could only extend to the midnight of 31/12/2015, and same would not cross the said deadline. As the beginning of 1/1/2016, that is from 00 hours of 1/1/2016, the respondent ceased to be a serving employee having superannuated on 31/12/2015. At no point of time on 1/1/2016, the respondent could have.
The relevant date is being considered 1/1/16.
Yes,
In our case,
it is 31.
in this case, the OM itself says 31/12.
No, my lord, the OM says it comes into effect from 1/4/2016. Paragraph 1, Roman 2, my lord. My lord, just allow me to complete this, my lord. At no point of time on 1/1/2016, the respondent could be said to be in active
No
service.
Similar OM in this case.
This is, my lord, the provisions of the 7th Central PCPC. We have adopted the Assam Central PC, which came into effect from 1/4/2016.
Yes, yet to incorporate a date that even those who are serving on 31st March, they will also be entitled to benefits.
No, my lord. My lord, here we have not said that. My lord, the language read with 4A and 4B, because here the Supreme Court said that on 1/4/2016, you are not an employee. So you are not entitled to the revision of pay, which came into effect from 1/1/2000.
Required to be in your OM, he was only required to be in service.
No, my lord. That's, my lord, my humble submission. My lord will examine this on all employees who were in service on 31 March 2016. My lord, this talks of the category of those employees which read with 4B, means who were employees and who carried forward from 1/1/4/2016 onwards. Otherwise, my lord, this provision, clause 1(2), which says that it will be deemed to have come into force from 1/4/2016, means that revision of pay, my lord, will have to occasion from 1/4/2016. My lord, if I may, if I've been able to, my lord, communicate what I wish to say, my lord, I'll test this, my lord. Let it be that he retired on 31/3/2016, and this OM says that it also covers employees on 31/3/2016. But my lord would note that the OM itself comes into being from 1/4/2016. So the revision, my lord, that is there, the pay, revised revision of pay, occasions on 1/4/2016 and not on 31/3/2016. My lord will have to view that in that view of the matter, my lord. On 31/3/2016, he was already covered by the earlier revision of pay. This new revision of pay, my lord, comes into force from 1/4/2016. So, my lord, even if my lord holds that this 4A, the language is such that it is, my lord, covers 31/3/2016, my lord, the revision cannot be acted or done on 31/3/2016. It has to be done on 1/4/2016, and on that day he is a pensioner, because his pension starts from that day. And that.
Yes. My lord, my learned friend is confusing with this aspect, my lord. If your lordship will kindly come to rule, my lord.
Yes.
Page 52, my lord.
Yes, please.
Now, my lord, one fundamental thing which needs to be clarified is, my lord, that revision of pay rule came into effect from 1/4/2016. And my lord, who all are entitled to it? Those who were on service or retired as on 31/12/2016. Now kindly see, my lord, 4A. All employees who were in service on 31st of March 2016 or who may have been appointed on or after 1st of April 2016 shall draw pay in the revised. Anyway, my lord, I'm not claiming any revision of pay being on service on or after 1st of April. All that I'm saying is my last pay should be revised since I retired on 31/3/16. My lord, your own rule says, where is the scope of argument? Kindly see, my lord, and kindly come to this rule at page 32, my lord. When does this will come? Page 55. Kindly see, my lord, rule 32, under which, my lord, they are now trying to settle our case. Family pension, family pension of existing pensioner, family pensioners in pre-so-and-so pensioner, family pensioners shall be revised with effect from so-and-so in the following manner. The revised basic family pension on 1/4/16 of the pensioner, family pensioner who were drawing pension on 31/3. I was not drawing pension on 31/3/16. I was drawing pay. So therefore, what is the wrong in the view taken by the learned single judge? And even if there is a possible view, my lord, as a writ appellate court, my lord, lordship will not substitute that view merely because another view is possible. There's absolutely nothing wrong in this view. It's a writ appeal is an appeal on principle, my lord. Merely because another view is possible, as my learned friend would like to suggest, in my humble submission, lordship will not substitute the view of the learned single judge. There's absolutely nothing.
Yes, maybe look at the basic pension. We detect for 1/4.
But for those who are already putting pension, by 30%. See, from the pressure of this poor balance.
And my lord, going by the fundamental principles of interpretation of statute, even if there is any ambiguity, my lord, the ambiguity has to resolve in favor of the employee.
That in case. Require the respondent to give an undertaking that in case you succeed, he'll reimburse. But we are not inclined to stay the order.
My lord will also do one thing. My lord will limit this order to the respondent.
Yes, of course.
And it will not be applicable to any other, because my lord, this will have a cascading effect in the organization and he will give an undertaking, my lord.
Yes, of course.
And with a bond, my lord. With a bond,
Admission
with
notice.
a bond of a.
Admission notice. Heard on the prayer for interim relief for the present, after having considered the submissions advanced at bar, we are not inclined to stay the effect and operation of the impugned order dated so and so passed by learned single judge. However, we make it clear that the order being passed by this court shall be limited to the case of the respondent herein, and that the respondent herein shall furnish an undertaking to the employer that to the appellant that in case of success of this appeal, he shall reimburse the excess amount, if any, paid to him on account of the order passed by learned single judge.
My lord, what I was trying to pray, my lord, that the order of the learned single judge will be, my lord, for the.
No, we can't do that. How can we do that? You already filed an appeal. It has been admitted. You can always say.
Tomorrow we'll have a plethora of writ petitions in the.
You can always say that there is already an appeal. That is one view which has been taken. We have not tinkered with the view so far. Yes.
And my lord,
provision like anticipatory bail will have to be incorporated to take care of my.
the language, English language, usage of the English language in the office is giving an undue advantage. Unfortunately for me, unfortunate, it's unfortunate.
They should have got it vetted.
Better drafted, my lord.
Vetted from my learned friend because he's an expert, my lord.
It's a compliment or a cut, I don't know, madam. It cannot be a compliment. And my lord, they have filed a contempt because in view of this order, my lord, let them not press the contempt for some time, my lord.
We are paying as well to the person contempt.
Fine, my lord. That assurance is enough.
By refusal of the interim relief, I'm getting pension.
Item number 21 of daily list.
Yes.
Wait, please, my lord. Matter pertains to matrimonial appeal.
Listen. Yes,
My lord, may kindly peruse the last order passed on 9/2/2020.
yes.
My lord, I have submitted the last drawn salary. If my lord would kindly come to the last page of the salary slip, my lord.
Yes.
My lord, the husband, the respondent is drawing a gross pay of 95,746 rupees and net pay of 65,266.
Yes.
My lord, may kindly allow us to have the enhanced monthly maintenance of rupees 25,000. In view of the same. A copy of the board.
Every stage of opinion, what is this aspect. What the maintenance. Results the experiment. Whether it should be back or maintenance. There was an order of restitution. It came back.
Law of the land is there.
Willful desertion. Willful desertion, there is no question of maintenance. That's the law.
Gray area.
That's the gray
Gray.
25%.
No, subject to is,
Yes.
this is supported by the payslip.
65,000. Is the excess. Maybe.
Copy.
Okay. Look at the money. In name of. It's already taken one time. Once. Yes. I say 25,000 for the wife and child is quite reasonable.
My lord, the problem is I have lost contact with my client for quite some time. I have communicated the last order. Still now, I have not received any communication instructions.
You need
from-
time?
Yeah, my lord. Maybe after 15 days time, I am sending another letter.
Counsel for the respondent, please, or it is granted 4 weeks time to complete our instructions. List of 4 weeks.
Highly obliged.
Matter number 22.
Please, your lordship. Your lordship have filed an affidavit in this case, your lordship,
Yes,
and this. Your lordships, I have filed this affidavit tomorrow, but because of the defect there, it is filed today, your lordships,
okay.
in IA, your lord.
Affidavit in relation to what?
In connection to the petition under section 25 permanent element.
Okay. Counsel so and so submits that he has filed an affidavit in response to the application under section 25 of the end of the legend, submitted on behalf of the appellant. The same be brought on record, list after 1 week.
Much better.
Matter number 23 and 24.
May I please, your lordship? So far as item number 23 is concerned, my lord, this petition is infractuous, my lord.
Infractuous,
Lordship, this petition filed for holding the JMC election.
which must already have been
Already
held
1 year back, it was held.
as stated by land council. MS so and so, comma, the instant, and in view of the subsequent developments, comma, the instant PIL petition is disposed of as having rendered infructuous. Pending applications, if any, are also disposed of.
Can I point out to your lordship one fact, Lord?
Yes,
In this application, Lord, do the PL pertain to Guwahati Municipal Corporation? Lord? Then I filed by the state of Assam, for Lord, not holding the election so far as Silchar municipality is concerned, Lord.
Mhm.
And now, Lord, the municipality has been constituted, Lord. And I appear on behalf of the State Election Commission, Lord. The process is on, Lord, for conducting the elections and all.
land council, Mr. So and so, appearing for the election commission, makes a statement that process for holding elections in the Silchar municipality is also initiated.
Initiated.
Very well.
Lord, the reservation of seats and all are depending upon the government.
Yeah.
Initiated.
Initiated. Has also been initiated.
The I can also be disposed.
The higher disposal.
May I please, your lord. My lord, item number 24, I am appearing, my lord.
Yes,
My lord, in this PIL, my lord, I have challenged the, my lord, amendment which was made by the state, my lord.
to
Because, my lord, it is unconstitutional, in view of the Article 243E of the Constitution of India, my lord. My lord, in fact, earlier there was also move, my lord, and this honorable court, my lord, plainly, my lord, held that this is
state has not filed affidavit.
not fine, my lord. Though earlier has taken time.
Where is Mr. Saikia? He was appearing.
My lord, today some personal difficulties not in court today, my lord. My lord, we grant my lord 2 days time, my lord.
Counter affidavit on behalf of the state has not been filed despite direction given on 5/5/22. It will be done within next 4 weeks. List on 26th April.
Most obliged.
Matter number 26 and 27.
Contempt.
Yes. SL.
SLP,
SLP pending since 2020. Now, I know, my lord, nothing has happened till today.
so
Neither stay has been given by the Supreme Court.
pendency by itself is sufficient.
That's why, that's the first day it was moved. Some review application was also filed by one, the Pawan Hans, they filed. State of Arunachal Pradesh went to.
We have filed the SLP.
SLP.
Wait for the, this SLP pending before Honorable Supreme Court. has still not been decided. List after 8 weeks,
Much obliged.
awaiting outcome of the matter pending before Supreme Court.
Matter number 28.
Lordship, matter may be passed over for the time being.
Yes.
Matter number 29.
Yeah.
Please, Lordship. Lordship, I am appearing on behalf of MS Digos.
Yes.
This PL was filed in the year 2022, seeking direction to estate if proposed eviction
Of,
in the district of Sonitpur.
now that is process is complete.
Yes, eviction has already been undertaken. So
In practice,
Lordship, direction may be given.
May I please, your lordship, lordship is in the same contention, your lordship, several other PLs were filed, those were disposed of. Lordship, I have furnished the order copies also. your
Yes.
lordship.
Rehabilitation part is
we'll
remain.
dispose it of in light of this order.
Done, your lordship.
All right.
Rehabilitation is done, your lordship.
Is already done.
Yes, your lordship. The similar cases are disposed of, your lordship, the same bunch of people, your lordship, same villages.
We'll dispose it of in the same manner. Okay. Then council, the AL at hand was filed with the prayer to restrain the state authorities from staying the action, seeking to restrain the state authorities from evicting the possession of the villagers of several villages from government land. This court is apprised that the process of eviction has already been completed. And counsel for the respondents has drawn the attention of the court to order dated passed, order dated so and so passed in a similar writ petition. Thus, comma,
PIL your lordship, as well as.
PIL,
Both are PILs. your lordship.
PIL's number so and so. In this way, the matter, comma, without recording separate reasons, comma, the instant PIL is also disposed of in light of the observations made and directions given in PIL number 76/2021. No order as to cost.
Pleasure.
Matter number 30.
Yes. None. None present for the parties. List of 6 weeks.
Matter number 32.
May I please, your lordship? Matter will pass over for time being, lordship. It's a decision village.
Pass.
Would like.
Matter number 33 to 35.
May I please, your lordship?
Yes.
My lord, here is a case. The contempt application has been listed along with the writ appeal, my lord.
Yes.
My lord, despite there being an order of the honorable single judge allowing me, my lord, to hold the office of the, my lord, president of Jila Parishad, my lord, the respondents are not allowing me, my lord, to function, my lord. In that context, my lord, the contempt has been filed and there is a, my lord, glaring, my lord, violation of the honorable court's direction, my lord.
What is for the contemners?
We are not appearing for the contempt, your lordship.
Notice issue position, huh?
Notice they will have to engage us, your lordship.
Service is not still complete. What is the service report in the contempt?
The order sheet.
1/2/23.
Yeah.
Notice.
17/3.
Yes. Copy of communication has been received from respondent number 2.
Yes.
But 1, 3 and 4, service is not complete.
Await service on respondent 1, 2 and 4.
Fresh.
1, 3 and 4. You want to issue fresh notice then? Take fresh steps.
My lord.
Petitioner is permitted to take fresh steps by registered post ID.
Can it be a shorter date? My lord?
Trustee is
My
also
term is coming to an end, my lord. As a president, my lord.
A list after 3 weeks,
2 weeks, my lord. Can it be?
The secret.
2 weeks.
Yes.
Then you take service by dusting.
My lord, Lordship will allow me. Well, can it be a date? My lord?
2 weeks.
Lordship, so far as respond number 4 in the contempt case is concerned, Lordship. Yesterday I received one Okalat Nama, Lordship.
Okay.
So I
Or
would like to
you would be appearing
Lordship.
So 1 and 3.
1 and 3.
Yes.
List on 3rd April, maybe.
No.
3rd April.
Obliged.
No, 3rd would not be 2 weeks.
10th.
11th April, 11th.
11.
Obliged.
2 and 4 services done. 1 and 3 fresh notice. Right.
Letter number 36.
Lordship, there was a delay of 32 days in filing preferring the appeal. Lordship. We have taken steps and we also saw copy personally to the respondent could not be found, but his mother accepted that we filed an affidavit to that regard. Lordship. So, Lordship,
Whether the registry doesn't say that the service is complete.
It doesn't say that, but I
Then-
filed an affidavit. We deputed a personnel officer of a Jawan from our Lordship department, and he went to his native village at Bihar, Lordship, and served the copy in presence of the Lordship, the officers of the police station, Lordship. That will, Lordship, I have annexed, Lordship.
Received by some Ashutosh. Who is Ashutosh? How do we know?
Now, he is the Thana Prabhari, Lordship.
The acknowledgement doesn't bear any signature.
Lordship, my clerk made a mistake, actually, Lordship. The petitioners, the respondent mother accepted that, Lordship.
There is no endorsement.
No found on permanent address. Was not found. That is what the report is. Is you to place on record.
Lordship.
Then the registry will make a report. And counsel, Mr. Chunchu, place for is granted. Time to place on record affidavit in support of proof of service. List after 1 week. All 3. Same respondent.
One respondent only, Lordship.
Okay. This is IA 2375. The others will come up along with 1 week.
Letter number 37.
Yes. ये वापस देना. Yes. No one is there. Mat appeals, mostly people don't turn up. None present. List of 6 weeks.
Letter number 38.
Made please allow. My lord, here we are assailing, my lord, the rule
Hearing,
6.
Yes, yes.
If your lordship would kindly come to page 13 of the petition, my lord. This is the unamended rule. It starts at page 12, my lord, in fact.
Police service rules.
Yes, my lord. Please come to rule 6 towards the bottom of page 12.
Yes.
Recruitment to the service after commencement of this rule shall be by following methods.
You're
Namely,
reading page 11.
page 12
Well,
of the petition.
yes. Yes.
I'll have your lordship's kind attention to rule 6. Recruitment to the service after commencement of this rule shall be by following methods, namely 50% of the substantive vacancies in junior grade of service which occur from time to time shall be filled up by selection from amongst the officers who have served the cadre of Inspector of Police under Government of Mizoram for not less than 5 years of a regular service in the grade. Provided that out of this percentage, one post of assistant commandant from each Mizoram Armed Police Battalion, India Reserve Battalion, shall be exclusively earmarked as promotional post of the Inspector of Mizoram Armed Police Battalion, Reserve India Reserve Battalion. Promotion shall be made by selection from Inspector of Mizoram Armed Police Battalion, Indian Reserve Battalion, who have served not less than 5 years in the grade. 50% of another substantive vacancies shall be filled up by direct recruitment to competitive examination as provided in this rule. So, my lord, we are concerned with this promotion part, 50%. 50% will be by direct recruitment and 50% will be by, my lord, promotion. Now, my lord, this
The rule doesn't say promotion by selection.
by selection.
What is the mode of selection?
Mode of selection is, my lord, seniority, my lord.
Where do we get that from?
Yes, my lord. It could go ahead.
172.
Could go ahead. Affidavit.
Affidavit.
Yes.
Right.
Affidavit filed by the state, my
These
lord.
are the rules. 172.
Internal page to give one.
So what is the mode of selection
Yes.
under clause 1?
Part 5, recruitment by selection. Rule
Yes.
7.
What is the criterion of selection, sir?
Malad, the commission will consider from time to time. Malad 7(1).
Okay.
7, my lord. The commission will consider from time to time.
Merit cum seniority.
Merit comes.
Merit cum seniority.
Commission will consider time to time cases of such officers eligible under taking into account the Excel vacancies at the time of selection. Selection shall be based on merit with, oh, sorry, my lord. It's a merit based selection.
Merit cum seniority.
Merit comes in. So essentially it's a merit. One who is in the zone of consideration, then merit will hold the field. Now, my lord, what had happened? This particular rule which I read at page 13, my lord, was amended in, my lord. That your lordship will get at 2008, the rules were amended at page 10.
172.
Oh, the first file.
Page 10, my lord, of the writ petition.
Yes.
Yes. Recruitment to the service after commencement of this rule shall be by following methods, namely 50% of the total sanctioned strength of the post in the junior grade of the service shall be filled up by selection from among the officers who have served in the cadre of Inspector of Police under the government of Mizoram for not less than 5 years of regular service in the grade, provided that out of this percentage, one post of assistant commandant from each Mizoram Armed Police Battalion, India Reserve Battalion, shall be promotional post. Now, earlier lordship had noticed at page 13, shall be exclusively earmarked. Now that has been substituted by, my lord, shall be promotional post of inspectors of Mizoram Armed. Now, my lord, the position, the ground reality.
Earmarked as a promotional post.
Now it will be only promotional post. And now, my lord, the scope of the proviso has been restricted. Earlier it was, my lord, I am on a slightly different plan. Let me place the facts, my lord. Now, Mizoram, my lord, the feather cadre post is both from armed branch as well as unarmed branch. Now, there are in Mizoram, my lord, there are about 8 battalions. And the total post is, my lord, 85. Mizoram junior grade MPS officer, total cadre strength is 85. Out of which, my lord, 42 or 0.5 or 43 is direct recruitment. And, my lord, 42.3 is for the promotional post. Then if we earmark 8 for the armed branch, then, my lord, 42 minus 8, that is 34 is for the unarmed branch and 8 is only for the armed branch. Now, my lord, if your lordship kindly goes to the proviso does not make any distinction between armed branch or unarmed branch. The proviso says, whosoever is in, my lord, the cadre of Inspector of Police under the government of Mizoram and who has put in 5 years of regular service, they are eligible for selection. Now, my only submission for your lordship's kind consideration in this case is whether a proviso can restrict the operation of the main part. In my humble understanding, my lord, the proviso has the potential of restricting the scope of the parent provision, which can't be, my lord.
There is a proviso quoted.
Yes. Page 10, my lord.
Yes.
Kindly see, my lord, I'm reading it once again.
Provided that.
No, before that, let me read the main provision. 50% of the total sanctioned strength of the post in junior grade of the service shall be filled up by selection from amongst the officers who have served in the cadre of Inspector of Police under Government of Mizoram. So, my lord, the parent provision says whosoever has served as in the grade of inspector in the Government of Mizoram and has put in 5 years of regular service, he is eligible to be considered for selection to the post of MPS junior grade. Now, the proviso brings in this, my lord, provided that out of this percentage, one post of assistant commandant from each Mizoram Armed Police Battalion, India Reserve Battalion, shall be promotional post of the Inspector of Mizoram Armed Police Battalion, India Reserve Battalion. So as a result, my lord,
They too are inspectors.
huh,
So the main part of the rule
is
that is a general avenue of promotion to inspectors.
inspector, irrespective of
This-
whether one is armed branch or unarmed
Yes.
branch.
Now,
Huh.
to give certain kind of incentive
Yeah,
to the battalions.
yes.
8 posts have been reserved for them.
In fact, that was the idea when the rule was amended earlier in 97 at page 13, before amendment.
Yes.
Kindly see, my lord, at page 13. On top, provided that out of this percentage, one post of assistant commandant from each Mizoram Armed Police Battalion, India Reserve Battalion shall be exclusively earmarked. It means, my lord, this in my humble understanding, subject to your lordship may say, in addition to other posts, one post in each, battalion will be reserved for armed branch. So it was.
What mathematical difference is this provision amendment making?
Huh.
Earlier also, these posts were earmarked.
Huh.
Now also they are
Yes,
reserved for promotion.
yes.
So what is the difference?
Now, my lord, they would like to give a meaning that now only will get only one post. That's why they.
You represent the armed battalions.
Armed battalion.
Only one,
One.
each.
One each, that means 8 battalion, 8 posts.
Earlier also it was one each.
No, my lord will kindly see, shall be exclusively earmarked.
One post of assistant commandant from each.
Each.
And again here, same thing.
My lord, there is some difference, my lord. Earlier, the purport of the rule was to give exclusivity, my lord. In other words, apart from, my lord, normally a proviso qualifies a main provision.
Yes.
So maybe what was the intention of the rulemaking authority initially when the 97 amendment was made, that every inspector, irrespective of whether he is armed branch or unarmed branch, they are all eligible provided they have 5 years of service.
Yes.
And they come within that, my lord, zone of consideration. Now, my lord, they say, oh, sorry, earlier they said, the provisor said, notwithstanding anything, one post each, irrespective, supposing, my lord, I'm just giving an example. Supposing the required number of, inspectors from the armed branch is not available. Even then, my lord, one seat would be earmarked in each of the battalions.
Yes.
That was the idea in my humble understanding.
Yes.
My lord. Now, my lord, by saying that there will be only one post, now they are making the intention by the proviso. Now they are trying to say by 2008 amendment that is not the deposit. The otherwise
One post from each battalion. Probably you are missing something.
provided that out of this percentage, that is that means 50, one post of assistant commandant
From
shall
each-
be promotional post.
For each.
Yes.
Battalion.
Yes, one post each.
So.
Anyway, my lord, let us not go to that controversy. I will stick to my principal argument, my lord. My principal argument is, my lord, can you restrict the operation of a provision by a provider?
Why not? Reasonable classification. What's wrong?
No, my lord, the decisions of the Supreme.
Position of rules in 1997 was same.
No, my lord.
Nobody was agreed on that.
To that extent, that is not my argument. What I'm trying to say, my lord,
Yes.
that the principal rule ensures all inspectors, irrespective of whether they are armed or unarmed, you are eligible for promotion, selection, provided you have put in 5 years of regular service.
Even by the proviso,
Yes.
whether those who fall in the principal rule, they are disqualified.
Yes. Only 8. They are confining it to 8.
Okay.
Now, as a matter of fact,
Yes.
out of 43 posts, my lord, only 8
are available.
inspectors from our branch is promoted, and the rest 34 is by them, my lord, by the unarmed branch. And although, my lord, in service we are senior.
You did not put it in this manner till now. You are going around in circles. Shall be the promotional post. So meaning that by they can't go
Beyond
the proviso.
Beyond proviso.
One post each, that would work out to 8.
8.
And what is the mode of selection to armed battalions and the general inspectors? There are different set of rules.
Same, my lord. Who do? No, my lord, as far as recruitment of unarmed branch is concerned, it is not same as like us, my lord. There are some people from us who have gone from Havildar also. Because
So
basically.
since your source of recruitment is different,
Slightly different.
why can't they restrict your promotional avenues?
So, my lord, that's what I'm saying.
Yes.
In case of those armed branch inspectors who are supposing not graduates, supposing who do not have the, my lord, required experience, in their case.
They are promoting you in your own branch. That's the only restriction. They are not allowing you to shift into the unarmed branch. That is what the difference is.
No, that is one way of looking at it, my lord.
Yes.
That I was only trying to say, when the, my lord, parent rule does not make any distinction.
Maybe. The
Whether
distinction
by
is sought to
virtue
be drawn. Distinction is sought to be drawn by the source of your recruitment. You are born into the armed branches.
Yes.
There is a promotional post which is provided to you, those who are working in the armed branch.
Yes.
And for the unarmed branch, they are not allowed access into the armed branch. So that is the
No, my
class
lord,
which is
there
created.
is some difference regarding the mode of recruitment and the nature of job that is there. Question is, my lord, amongst the armed branch,
Yes.
those who are, my lord, otherwise eligible, why their cases are not considered? Why it should be confined to one? I can appreciate, my lord, a matriculated Havaldar, he cannot be brought into, my lord, Mizoram.
Do we have that kind of pleadings in this petition?
Yes.
That your clients are eligible to be considered?
Yes.
Where is that?
Yes.
Let's see.
In fact, my lord, the Director General of the Police even wrote to the government also. And initially, the last time, my lord, learned Additional Advocate General for the state handed over a copy of the affidavit, which was filed in 2018, where, my lord, in fact, the proposal was approved by the Home Minister. But some representation was filed by the unarmed branch, my lord. Then the, my lord, status quo was maintained. That matter was not carried forward any further. That aspect has come out in the affidavit filed by them, my lord.
What are the qualifications of these inspectors of police of unarmed branches and the qualifications?
I think, my lord, there is a sub-inspector level post as a graduates, my lord.
Graduates. Right. So in your case, even
It's on promotional, so it's from the SSLC. Lords.
what are the educational qualifications of your clients
No, my
as
lord.
per the service rules?
No, my lord, my humble submission is, when we want to enter the Mizoram Police Service, then we have to comply with all the requirements of the
True.
recruitment
So-
rules.
So
there,
now
my
you
lord-
want to shift into the Mizoram Police Service?
Yes.
Even though you are not entitled to be
No.
directly considered in those.
No. What I'm saying is, my lord,
Yes.
there are inspectors in our, branch, my lord, who are competent enough, who are graduate or
Let us see
everybody.
the pleadings.
Yes.
Then there has to be a specific case
Yes.
on behalf of those persons who are eligible.
In fact, my lord, there was some consensus in this regard
Yes.
When the other, my lord, the rival association agreed to that.
Let us see your,
Yes, yes.
your petition is on behalf of four petitioners.
My lord will kindly come to page 24, my lord.
Yes.
Paragraph 8.
24. Yes.
That to make the case of the petitioner more coherent, the petitioner begs to place certain facts in tabular format herein below. Total sanction strength of inspector, unarmed branch 81, armed branch 69. Number of posts occupied by promotee inspector in the junior grade of the service 34, armed branch 8. Total sanction strength of the two cadre is 2693 and 6481.
Mr. Chaudhary, what question we are putting to you
No, I'm-
is, where is that pleading? that
Yes.
Your clients are
Same-
otherwise qualified to hold the post of
Yes, my lord.
Inspector?
Kindly have a look at the, my lord, the subpara. Before adverting on the grounds for challenge, it be stated herein that a perusal of the table appended above would clearly show the disparity between the persons of the same rank belonging to the different branches. Moreover, such disparity exists even though general rule contained in Rule 6 does not differentiate between the two branches. In spite of the general rule, the proviso appended thereto completely negates the object and purport of the general rule. Under such circumstances, the petitioners, along with other persons similarly situated, are discriminated and classified prejudicially without any just and cogent reason. As such, the rule in question classifies two branches of person belonging to the same class into a class relation and cannot in any stretch of imagination be considered as a reasonable classification. As the rule in question shall be so and so. Then my lord will kindly come to
This doesn't answer our query, sir.
no, yes, sir, true, my lord. Now, please come to 8th, my lord, at 27.
Yes.
For that, even assuming but not admitting the two branches to be classifiable, such classification would not stand the test of reasonability inasmuch as armed branch personnel starting their career as constable or havildar are already old till the time they are promoted to the post of inspector. Even after being promoted to the junior grade of the Mizoram police, it is virtually impossible for armed branch personnel to get promoted further to the senior grade deputy commandant, additional commandant, in view of the fact that minimum 5 years of experience along with requirement for appearing in departmental examination is required for promotion. Therefore, any armed branch personnel can rarely reach the senior grade.
Right.
He took what? He took what, eh?
That is because you opted to
No, I got your.
be
lordship's
born in
point.
that service. Seems that you are preparing the brief while standing on the dais.
My lord.
You are preparing the brief while standing on the dais.
No, my lord, all that I was trying to submit for your lordship's kind consideration is, now question is, my lord, when there is no scope to enter the competition, we are agreed by that. Once we are considered, we are found unfit, reject, our cases are rejected, that's a different thing. But because of the capping of 8 seat, my lord, we are not considered, even if we are there.
Question, that is why, again, the same question. How are you born in the service? Your very entry in the service and their entry in the service by a different process.
No, my lord.
So
But no question is, my lord,
is,
my lord, even after that, when there are eligible people whose case can be considered. Now, my lord, it's true, my lord.
this is not the case set up in your petition, sir.
No, our case is, my lord, the Rule 6 does not make any distinction. It is the provider which seeks to make the distinction. Therefore,
The
a
argument which you are trying to build up for having the rule declared ultra virus is that there are certain persons in your service who are qualified to be inspectors
Yes.
of unarmed branch.
Yes.
Where is that pleading, please?
No, no, we are not saying we are qualified to be, become unarmed branch inspector. We are already inspectors. Question is, my lord, as an inspector, our chances of consideration has been confined,
Yes,
even if we are otherwise eligible.
that is relatable to your source. So If your source is different, then they definitely have a right to make a distinction, saying that no, we don't want them to be in an armed branch. That is what this distinction is, and that is reasonable. All right, thank you. Yes, please.
No, Lordship will kindly give me some time. Huh? No, my lord. No, my lord, it's not that any special qualification is required, which we are not.
We have been putting that query right from the beginning, sir. You have been given different type of answers.
No. No, Lordship will kindly give me some time, my lord. I think I'll have to.
You know, as the saying goes,
I have taken some
the-
time of your lordship.
a lawyer can argue even before a lamppost. Presume that we are lampposts. We can put any kind of questions.
No, my lord.
Yes.
True, true. My only submission is, my lord, I'll just place two judgments, please, my lord, have a look at it.
So then we are concluding.
We will have it on another day, my lord, we'll satisfy your lordship.
List of 4 weeks. As per it by Mr. Chaudhary. Seems to be a case of inappropriate fuel being filled in the car. So the energy is lacking.
From the birth to the MPS service, there is a clear challenge.
Must be.
No, I think, my
That's what
lord,
we could
the
comprehend.
quota could have been slightly more, my lord. We're only on that.
Whether we can decide what should be the quota.
In fact, my lord, the DGP wrote, there is a lot of resentment.
You can
my lord.
always represent, we can direct the authorities to consider your representation, but otherwise rule is not liable to be tinkered with. We are very firm on that. If you want that
My
liberty,
lord, when
we can do
we
that.
accepted the brief, we could see all this, I mean, which all are against us. But we thought, my lord, by reading that proviso, maybe we'll be able to persuade your lordships.
So far, it's doesn't
Anyway, my
seem to
lord.
be.
If you provide
The
those,
qualifications are different.
None of them will be promoted. That's the situation in the.
Right.
Correct.
Anyway, my lord, we'll have it on the next day.
The matter lives for another day. To see the light of another day. Very well. I left. He was just.
Item number 14 with 41.
Yes.
May I please?
Yes.
Malo, it's that tender matter, wherein.
Council was there in the
Yes, yeah, Malo. Right.
first round.
He's here, Malo. He's
here.
Malo, if I may just put it in the context, Malo. My lord, an NIT was issued.
So the appellant's tender has been found compliant after that committee report.
After the, no, my lord, there is a differentiation here. The compliancy was not even gone into. What was gone into? The eligibility, they were all treated to be eligible, and then, my lord, who will get the work?
Yes.
It's on that aspect, my lord, wherein the respondents proceeded and a speaking order was passed. I have filed an IA by way of an abundant question, assailing that. My lord, the issue before the honorable single judge was whether the
Your IA number 800.
lordship, lordship.
Yes.
My lord, I have just made a challenge to the speaking order, my lord.
Yes.
Lordship, if I may have my lord's attention to the tender itself.
Yes.
Page 43 of the appeal memo.
Page 43. Hmm.
43, my lord. Oh, sorry, page 87, sorry, my lord, 87. Last to come. My lord, the work at serial number 4.
Just hold on. 80. Yes.
The work at serial number 4, my lord. Udalguri. Construction of a road from so and so, so and so. This is the, my lord, works tender, 87, my lord.
Yes. Double pagination.
My lord, yes, on the left-hand side, they have kept the writ petition pagination, and the middle,
Yes.
my lord, would
87.
find it.
Yes.
Serial number 4 is the work, my lord.
Udalgiri.
Lordship, Udalguri. Construction of road from Pasia so and so, including construction of RCC bridge in so and so for the year 1920. The reserve estimated value was, my lord, 10 crores.
Yes.
Now, my lord, the conditions, page 96, my lord.
Yes.
Now, my lord, what had happened here was, there was no pre-qualification conducted by the department. So, my lord, clause 4.3 was incorporated. If the employer has not undertaken pre-qualification of potential bidders, all bidders shall furnish the following information documents with their bids in section 2. My lord, I'll have my lord attention at 97, clause F.
Yes.
Reports on the financial standing of the bidder, such as profit and loss statement and auditor's report for last 5 years. Now, my lord, clause 4.3 pertains to a pre-qualification examination. After this is done, my lord will have 4.5.
Yes.
To qualify for award of the contract. To get into the contract, my lord, 4.3 has to be satisfied. And after that, 4.5, to qualify for award of the contract, each bidder in its name should have in the last 5 years referred to in the appendix done these works. Any of this, my lord, he will have to satisfy. Like, my lord, achieved a minimum financial turnover of 60% in any of the last 5 years.
Yes.
But 5 years financial reports have to be given to come into this. Now, my case before the Honorable Single Judge was, he did not satisfy 4.3.f. The case projected by the respondents was that no, forget that. He is satisfying 4.5, so we are making him eligible. Now, my lord would have page 100.
Hundred.
12.1. 12.1. Please.
Yes.
Certificates undertaking affidavits as specified in section 2. So this would be, now what would be a technical bid, my lord? That my lord would find at 103.
Yes.
My lord, 19.2 at 103 is the technical bid. I'll have my lord's attention at clause 19.2a, Romans 3, my lord. Annual financial turnover certificate of last 5 years showing money received from civil work contract duly signed by a CA. And 7, Roman 7, other documents, information as mentioned at clause 4.3 of the information to bidders, ITBP. That, my lord, ITBP, my lord would find at page 110. Here, my lord.
ITB.
ITB, my lord. 103, clause 3 and 7, and ITB 110. Sorry, well, it starts at 109.
109.
Clause 4.3.3, the information record from the bidders as per clause 4.3. So those requirements have to be given.
Must
submit. Must. Then, my lord, 2, just below my lord, 2, my lord will find a 2. E. Audited balance sheet submitted by so-and-so for last 5 years, showing amount from receipt from civil contracts. Now, my lord, what would be the 5 years? For this purpose, 4.3, my lord would come to page 110 too. The last 5 years, furnish the information below under 3 and 4 for the following financial years, 2015-16 to 1920. He did not give anything for 1920. Now, then my lord would see there is a 4.58. This is after you qualify 4.3 the conditions, and then you come to 4.5. Now, my lord, if my lord can have page 114.
Yes.
This is section 2, my lord. Section 2 starts from here. I'll just have my lord attention qualification information. The information to be filled in by the bidder in the following pages will be used for the purpose of post-qualification.
Yes.
So means, my lord, 4.3, that's pre, and 4.4 is post.
Yes.
Now, my lord, if your lordship can have page 187, my lord. Or my lord can come to page 230. There is a, my lord, a type copy there.
Yes.
230, my lord.
230.
230, my lord.
Yes.
My lord, this is the annual financial turnover during the last 5 years. My lord, 2015-16 he gave. He is, my lord, at serial number 3, Pavitra Boro, and I am at the last.
1920 dash.
Dash. He did not give. And then
This is pre-qualification.
this is a pre-qualification. This is what was missed out, my lord, on the last year. And my lord, the last year, it's a financial standing. He might have satisfied. There is no problem. But the financial standing as of 1920 was required. It's a mandatory condition, shall. My lord, there was an interim direction passed in this first. My lord, if I may just, my lord, did not go into that. There was an interim direction passed not to proceed with the work. Thereafter, they filed a vacating application. Therein also tentative views that this honorable court came to the conclusion that 4.3 is a pre-qualification bidder and a pre-qualification not having been done. So those documents are mandatory and the stay was protected. It was not vacated. Thereafter, the matter went for final hearing. Final order, my lord would find at page, it starts at page 267.
Yes.
The arguments were noted, my lord. I'll not trouble your lordship with the arguments and the conclusion. I'll take straight to the, my lord. Para 31, my lord.
Yes.
Page 281. These are the conclusions. The expression used in clause 4.3 is shall. And as revealed above under clause F, the bidders were required to furnish reports of financial standing, which would include profit and loss statements and auditor's report for the last 5 years. It is not in dispute that the said clause would come into play as precondition has been fulfilled, namely the employer not having undertaken pre-qualification of the bidders. Now para 34, madam. The first defense on the merits of clause 4.3F has to be read with clause 4.5A of the tender condition does not appear to be reasonable. That was what they were trying to project. 34. Not reasonable, though there is no dispute to the settled principle that the author of the bid document would be the best person to interpret the clauses. It also to be taken into account that such interpretation has to be a reasonable one and should not be against the plain meaning of the same. As indicated above, the expression used in clause 4.3 is shall, and under subclause F, credentials regarding the financial standing of the bidders for the last 5 years are to be given. On the other hand, clause 4.5AA is to determine the eligibility by achieving a minimum financial turnover of certain percentage of works in any one of the 5 years referred to in the appendix. The eligibility criterion laid down in so-and-so is a distinct and different criterion than that of 4.3F. The aforesaid finding is fortified by the appendix to the ITB, which also specifically mentioned the years for which the information is to be given. In view of the above, this court is of the unhesitating opinion that 4.3F and 4.5AA are distinct and different clauses which are to be independently fulfilled. 36, my lord. The aforesaid contention is wholly untenable both in law and in fact. That means, my lord, they were trying to bring in 4.5A for award of the contract. Clause 4.3F is an independent and distinct clause which cannot be read with 4.5AA. The requirement of furnishing reports on the financial standing of the bidder for past 5 years is for the purpose of ascertaining the financial soundness and capability of the bidder to complete the work, and is one of the most important factors.
How do they consider the suspect?
My lord would now come to the speaking order.
Speaking order. Yes.
My lord, in my affidavit, that IA, page 19, it starts. My lord.
Yes, we have the original.
Lordship. My lord, after quoting your my lord's order, re-notify so-and-so, we have given our due consideration to the aforesaid order, and in compliance of the same, we have re-examined the entire matter, keeping in view the financial bids and other associate documents submitted by all equally placed L1 bidders in order to arrive at an objective decision regarding allotment of work in question. While re-examining the documents submitted by all equally placed L1 bidders, it is found that all the 3 bidders are technically qualified as per relevant clauses of the bidding documents. To take an objective decision regarding allotment of the work in question, the qualifying documents in respect of so-and-so submitted by L1 bidders are re-examined. It's found that bidder so-and-so has submitted more numbers of completed works in comparison to the other 2 bidders. So-and-so are started below. Then, my lord, you do it. And finally, at page 21,
yes.
we have given our due consideration to the facts and figures submitted by all the equally placed L1 bidders. We have also re-examined all relevant documents and made an objective approach to the above facts. Since all the equally placed L1 bidders are financially stable as per the submitted documents, past experience become the key factor while arriving at the present decision. Taking note of the past performance of completion of similar projects, we have deemed it proper to select so-and-so and allot the work to Procedural. My lord, this aspect of the matter that he could not have even come into the consideration of 4.5A was never considered. Right.
State, does the state propose to file a response to his IA? Then you should have said it out at the outset. Why you unnecessarily wasted so much of time? Then you could have made the mention immediately, Mr. Counsel. They have challenged your speaking order. You don't want to defend it. Then this is ridiculous. You want to file anything against this? IA?
Yes, I can satisfy lordship also on the.
Orally? Very well, carry on
We'll
then.
file our objection also. My lord, my learned friend has not gone to section 2. The entire case hinges on section 2. He
Do you
referred
want to,
to.
Mr. Counsel, do you want to file any?
Yes,
affidavit in
then
opposition?
since the state has also.
Okay. IA number 800/23 has been filed on behalf of the writ petitioner respondent. Question seeking to assail the speaking order dated 9th March 2023, passed by these authorities, employer authorities, pursuant to the order dated 28/2/2023. In this appeal, in the appeal, 7 days time is granted to the Nateful re-notify on 30th. Yes.
Applies.
Okay. So remaining matters will have to up to. We have 115. 115, we have another meeting. We are doing reviewing the line. IV matter. No. The councils have gone. Yes. They requested that. Very well. We'll resume at 2.
We had a video conferencing meeting on 17th of March. Now, lordships, as per the direction of this Honorable Court, the certain parameters on whether the contractor responsible for M&R, the maintenance and repair works, Chapu & Co. qualifies or not. The lordship, the relevant fact is that in Nagaland, not even a single contractor qualifies as a single entity, lordship. But if you go by the NIT dated 2nd of February 2023, lordship, there is a provision for joint venture. And for joint venture, lordship, MS Chapu & Co. along with MS Vilile Kamu and Sons, as a joint venture, we qualify, lordship. We do have some technical concerns also in this, but since we qualify and we have placed our papers before the NHIDCL for consideration, my lords may kindly take that into consideration, and my learned friend will be in a better position to clarify to your lordships.
Your lordship, as per as on the last occasion, my lord has passed the order where your lordship, being allied to the peculiar circumstances and larger public interest in concern, your lordship has asked us that can we have a deliberation with the M&R contractor?
Yes.
And my lord, before I put the seal covers, your lordship, what my friend is submitting, in fact, it is correct. My lord, I would like to place the communications which I have given to the NHIDCL.
Yes, please.
Because in that case, it will be better, my lord, to put it. My lord, in the communications, your lordship will find that I have communicated the order and I asked the NHIDCL authorities to have the deliberations.
Yes.
And particularly with 3 aspects that the parameters of NHIDCL NIT should be looked into it.
Yes.
Second thing, last one was that the corrigendum which they have issued. There should be a corrigendum to be issued that the holding of the NIT in persons of this court's order. Then on 17th of March, they had a deliberation, my lord. I joined through VC. We had a deliberation and rightly pointed out, since their representative was there, that appointed query was raised by the GM PMU Dimapur, my lord, who looks in the project, that whether Chabu and Co, that entity, whether he can come through as a joint venture. Then the technical head said that yes, it can be. So the deliberation was held, my lord. I have got a copy of the deliberation, my lord, with me.
Yes.
After that, the ED Kohima, they had a discussion with me over telephone. My lord, there is an email, your lordship, where I have given a detailed view that to a pointed query that whether the papers submitted by Chabu and Co as a joint venture can be looked into, particularly with respect to High Court's order.
Yes.
My lord, I have giving my due indulgence in this matter.
Yes.
And particularly looking at the order and the RFP, request for proposal. My lord, to my understanding, I opine that yes, a particular bidder, if he comes through as a joint bidder, as per the RFP, he can be looked into.
Okay.
So that was my opinion, my lord. Now, as per the directions of the High Court,
yes,
2 seal cover proceedings, they have done it.
Right.
I would like to place it.
So first you let us know whether in view of this development and the submission which is coming from the appellant side,
my lord,
would it be feasible to direct the NHIDCL to now undertake this exercise of examining a proposed joint bid?
My lord, I will, being an officer of the court, let me be very fair.
Yes.
My lord, they have put the papers and we have gone through the deliberation as far as the minutes which I have received.
Our anxiety is get the road constructed.
My lord, they are qualified. We have done the deliberation.
Yes.
Let me put it in this way. My lord, you will appreciate my concern. Since I am in PSU, my lord, our hands are tied. I can understand when I had a deliberation with my colleagues in the headquarters, they were of the view that since your lordship has asked only Sabu and Co, so we did not want to look into that.
Okay. So now that going further with this development and with the communication also indicating that this proposal has come through, would you be interested in considering that rather than a fresh NIT?
My lord,
you take a lot more time.
My lord, your lordship may kindly come to these minutes. I have one minute which I have received.
Yes.
My lord, I have got only one copy. I
Sure.
took it out.
No issues, no issues, please.
Do you have a spare copy of that minute?
No issues, no issues. We'll have it.
As per the 17.3, my lord.
Yes.
Do you have a copy of the extra minute? Yes, my lord. Kindly come to third page, my lord.
Yes.
After evaluating the documents, my lord, submitted by the committee, observed that the Chabu and Co is not qualifying in the technical parameters as a sole bidder, but qualifying as a joint bidder along with MS Vilele Khamo and Sons. So that deliberation was done, my lord. But what I am
beyond the scope of this court order. That is why hesitation.
Our hesitation was there.
We understand. We understand. Yes.
A hesitation was there.
The litigation and the road. Yes. How much time would you require to finalize the terms?
My lord, what I can make it out, my lord, this is purely as a public spirited cause only, my lord.
Obviously, obviously.
My lord, if your lordship passed the order directing that since the seal cover, it will be.
We will see that. Most likely it will contain nothing else but this minutes you have said.
My lord,
let us see that. Let us see that.
Yes, my lord.
Yes.
Since my lord, on the last occasion, if your lordship, the recent event development happened in OROP matter.
That is a different thing. Yes. That's a different thing. The government trying to hide its things in a seal cover.
Seal cover.
This is what has been done pursuant to the court's direction.
My lord.
So before the beans spill out, we would like to have a look at those.
My lord, I anticipate that we are treating it, to be very frank, my lord, that as per the sole bidder, we are not going into joint venture aspect, but that is one communication is there. The PMU has sent me.
Yes, we understand. Open it, yes.
Okay, yeah. हमारा mute है।
Is not qualifying. These are just the minutes you are carrying with you. Nothing other than that.
Yes, my lord, that in that, what happened in that earlier minutes, my lord, on 17, which we had, my lord, there we looked into the joint venture. He's qualified because he submitted the papers.
Yes.
But since we are hesitant on that aspect,
No issues. No
if your
issues.
lordship clarified and passed the order, we can.
Same thing, same thing. It's just these 3 minutes. They are nothing. In the public, but otherwise we are also taking that's public, let's be permit them to examine, join with, come out with their decision on that. How much time would you require to examine the joint bid?
Lord, Lord, let us be within a week's period of time.
How much?
Within a 1 week period of
Basically, you already examined it.
I will-
The viability you have already, tentative decision is there.
My lord.
Why do you want 1 week?
Then your lordship.
As my lord says, rainy season is coming.
Then your lordship, if your lordship taking into all facts into consideration, I may
Yes.
suggest in on this way, taking all facts into considerations, plus the our interest, if your lordship pass the order that as per the records, all on the records, if your
Yes.
lordship says that let us let us proceed with the work as a joint venture.
Yes.
We are ready to do that. But one issue is there, my lord. Let me be the MH Chabu and Co. has done the maintenance work.
Yes.
My lord, that's why I called the authority engineer also here.
Mhm.
They have done the maintenance work. So I had a deliberation with the technical person. They are saying that the amount which has been quoted in the NIT, that is 146 CR.
Mhm.
So the work which they have done, that comes down to, if you minus it, it comes down to 119.
That is why you have the deliberations. Come out with the final figure and get a stamp of approval from the court.
My lord, it can be done. Your lordship may pass that order, then one step can be cut down. Because
Yes.
since deliberation has already held,
Yes.
if your lordship has that as per the RFP, they are qualified, I can place the clause also, lordship. If your lordship wants to.
Please, please.
RFP. Give me the RFP. Have you marked it? I have marked it, my lord.
Yes. Heard learned council parties. Anyone wants to address from Kohima?
Lordship. We are supporting the proposal, Lordship.
Very well. Okay. Third and council for the parties. Consequent to the direction given on 14/3/2023, comma, deliberations to examine the qualification of Messrs. So and so, Chabo and Company, for proceeding with the balance work of the subject package were held. The conclusions have been placed on record in a sealed cover, which was opened in the court. As per para K of the conclusions, comma, Messrs. Chabo and Company is not qualifying in the technical parameters as a sole bidder. However, in this exercise, comma, the other bidder, the bidder, Messrs. So and so, was also placed its papers and a proposal to present a joint bid with joint venture bid with Messrs. Chabau and Company, which has been found to be viable.
No, not Chabu and Company, it's Villel and Khamo.
Villel and Khamo with
Chabu.
Chabu. Also, the PIL at hand involves the issue of construction of the National Highway package number so and so, which is a work of great public importance. in this background, exploring every possibility of expeditious completion of the work whilst brushing aside the technicalities is of paramount importance. In this background, we hereby direct the NHIDCL to consider the proposal of joint venture bid in light of the RFP clause number 2.1.11. The exercise in this regard shall be completed within 3 days from today. That should be enough.
My lord,
You already done the work. Now it's just to put it in black and white.
my lord, that amount aspect is there. The
7
amount-
days from today.
My lord.
All right. Re-notify on 31st
31st, my lord.
31st March.
My lords, there's one more aspect of the
Yes.
matter, my lord. This is an IE listed today in this matter. I appeared for respondent number 12.
Yes.
Who was the erstwhile contractor for package 3.
Yes.
My lords, in this matter, in October 2022, November,
Give me the
you
order.
deposited 11 crores before the honorable court pursuant to the directions.
Wait till 31st. We'll pass order on.
My lords, if I may just take 30 seconds, my lords. My lords, this order operates, is a very, very onerous order on me.
Wait for 7
Practically
days more.
amounts to
7 days
financial
more.
Death of the organization, my lords. And there is a reason that I say this, my lords. This
This
is
council, otherwise the matter has gone to arbitration. What is the point withholding that amount?
My lord,
And
the
my lord,
thing
not
is,
just
my
that.
lord, your lordship, what my friend is making a pair, you know, whatever is happening today is because of their conduct.
That is true.
My lord.
But whether we can, the court can proceed contrary to the settled
My
principles.
lord, let me look into that aspect. 1 week is a fair time. If they have waited for such a long period, let me have a
Wait,
deliberation.
Mr. Chug, wait for 7 days
My
more.
lords, just one submission. My
Yes.
lords have been very kind and patient with me. My lords, in this case, I suffer a triple whammy, and I'll tell my lords how. My lords, in this case, my bank guarantee of 3.5 crores has been encashed. I've been declared a non-performer. I've been blacklisted, and this is an automatic debarment clause, which is unconstitutional on the face of it. The moment they terminate my contract, they debar me from all contracts.
You have tolerated these things
Well,
for
this
so
was
long.
October.
7 days more.
My lord, let the order be communicated through email to us.
The order shall be, copy of the order shall be provided to all parties through email.
My lord, Chabu and Kobe implemented, my lord. Since
The, in view of the facts noted above, the MNP,
MNR contract.
MNR contractor message so and so is implemented as a party respondent in this petition.
Copy your email, my lord.
Thank you.
Much obliged, Lordship.
Basic object was to upgrade their education level so that they can compete with the other boys also.
Yes.
And pursuant to it, my lord, employment were made on contractual basis. Different categories employment were made, and my lord, the present petitioner were appointed in 2007-8 as a account assistant cum caretaker, my lord. Now thereafter, my lord, they are discharging their duty without any dispute, and my lord, everything was good enough. In 2017, my lord, what happened? A policy was adopted for upgradation of that education level. Out of which, my lord, the categories of employees, certain employees were fixed for, my lord, AMR for female. But so far, the present petitioners, appellants are concerned, my lord, and another category, my lord, there is no such, my lord, particular gender, my lord, that difference has been created, my lord. Therefore, my lord, in 2022, what happened might be a matter of misreading. My lord, a transport order was directed to be issued to the all concerned authority that from the, my lord, that Kastubha Vidyalaya, the employee has to be shifted to the, my lord, a new institution that is.
Male employees.
Yes, my lord. Now, question is that, my lord, two things are very important. Guidelines nowhere says, my lord. Now, once guideline doesn't say, my lord, then it is just an action contrary to the guideline itself, my lord, which is bad in law. Second thing, my lord, kindly see, my lord, these are the contractual employees, my lord, with very minimum salary, my lord. They are working and they are totally doing administrative job, my lord, which is nowhere connected with either into the, my lord, hostel premises or to the educational, my lord, that premises, my lord. Nothing they have to do, my lord. So the question is that, my lord, otherwise also a case of, my lord, gender discrimination, Article 14-16 come into play. Anyway, my lord, my humble submission, my lord, these are, my lord, very, my lord, persons with a limited salary, they are working. Suppose they shift to some other place, my lord, they need, my lord, lot of arrangement. And my lord, that will affect their seniority level also, my lord. Suppose they will join the new institution.
the whatever service they have discharged, my lord.
Contractual employees, what's the question of seniority?
My lord, suppose in case of regulation, my lord, then my lord,
Yes,
there is
that
a-
length of service will remain.
My lord, the question is that suppose there is a procedure of, my lord, regulation of service, my lord. Once regulation, then expense will count, my lord. Now, if they
So
have,
experience is not being washed off now by the transfer.
but my lord, sometimes, my lord, lord, a little bit right, somewhere lights are there, my lord. That suppose if 10 years a person will working, that will little bit give a preferential part, my lord. My lord, my humble submission at this moment, my lord, that the direction itself is, my lord, in contrary to the guidelines itself, my lord.
Which guideline?
My lord, kindly say. Lordship, just take a turn to my lord page. Page 48, my lord.
Yes.
My lord, the page start from page 46. I'm just reading that operative part. Page 48, lordship, kindly say. These are selection of teaching and non teaching staff. Warden come teacher. Column 3, position reserved for female candidate.
Yes.
Now, lordship, just take a turn to next page. Full-time assistant teacher. Roman column 2, it is also reserved for female candidate. And see that we are dealing with, my lord, appellants. It is not reserved for any, my lord, female candidate.
Maybe. Now they have taken a conscious decision that in KGBs, they only want female staff. What is wrong in that?
Quite right, my lord.
Balika Vidyalaya.
My lord.
They want.
Quite right, my lord. Absolutely. Lordship, I understood that protection or suppose security purpose, whatever, my lord, that let's. I'm not, my lord, denying. Lordship, kindly see our background. Last, my lord, more than 1 decade we are servicing. There is no such situation that has arisen. Otherwise,
You've not been thrown out of service, sir. You've been shifted to a different institution.
my lord.
On the same pay you are getting. There's no reduction in pay.
My lord, yes, my lord. The pay will also affect, my lord, because the position that has been not maintained, and there is no such, my lord, that how our the last duty that we have discharged, because residential, non-residential, there are two parts. Earlier we have worked as a non-residential. Now we have been confined to residential, my lord. So therefore, my lord, the accommodation, everything is required to be done, dealt with, my lord. And question is that, my lord, the policy doesn't say so. If policy doesn't say so, because, my lord, the authority which, my lord, passed the order, lordship, can you see the imping order contained in page 62? Lordship, just have a look for a moment.
Yes.
Page 62, column 2 clearly says, following position of NSC DAB are to be filled up by transferring the existing male staff to in KG type 2 and 3, preferably to the NSDAB in your district as mentioned below, and we are dealing with column number 1, administrative assistant. Question is that, my lord, it has not been sought for in the guidelines itself, and they are acting in the light of the guidelines, my lord. And lordship, kindly see that if this will happen, my lord, then the person who are already working there, suppose that position will be vacant. Then who will be filled up? Again, male.
That is the problem of the government.
No, my lord, kindly see that again male will come there. Because
We don't know. If male persons are appointed, then you can revive your prayer.
My question is that, my lord, because the guideline itself says it is not meant for female. So suppose if new recruitment will come from male, my lord, what is the harm? Suppose if
We don't know. We can't just presume that they will appoint new persons
already
from male gender
as
on
per
those
our
places.
information, my lord, some process has already been initiated. Once we came out, my lord, and some letter of transfer has already been issued, then, my lord, that will be filled up obviously by, my lord, way of advertisement. And once that advertisement can obviously
Let the advertisement be placed on record. They plan to fill it by male persons. We'll see.
Quite right, my lord. But as on today, my kindly see that already we have proceeded further, my lord, in regard to that, my lord, guidelines, my lord. And the guidelines is totally silent on that point, my lord. Why they would like to suppose affects our interest, my lord? Because other officers who are supposed, those who are supposed teachers, etc.
Okay.
Okay.
My lord.
This is not, it doesn't say the females are excluded.
Clearly says.
Where?
The lordship page, the policy, there is a specific, lordship, the reason that page 48, page 48,
Yes.
lordship, different categories of employees are there. And so far, my case is concerned, C, account assistant come caretaker. It nowhere says, because if there is a female earmark, then obviously it would be there.
That's what I'm saying. That's what I'm saying, that it is not reserved for male.
Yes.
It is gender neutral.
It's a quite, my lord, clear that.
No, that means it is a gender neutral post.
Lordship can say G, Chokidar. Chokidar come Malik. It is also not, my lord, reserved for female.
Gender neutral. It can be male, it can be female.
Then there's a policy decision to post all females.
My lord.
Nothing wrong.
Policy decision cannot be contrary to the guidelines which is set down
The
by the.
guideline doesn't say so, Mr. Taman.
These are not statutory rules.
Absolutely.
They're just guidelines.
Guidelines.
They have to be generally adhered to.
My lord.
You can't insist that every condition of guidelines must be followed. Thank you.
Heard Mr. Chabari, learned counsel for the appellant. Mr. Nayak for respondents.
I am appearing for the SSA authority, Lordship.
SSA.
Yes, Sarva Shiksha, Samagra Shiksha.
Samagra. Anyone else? MS M. Bhattacharya for respondents 5 and 6. You are there? And MS so and so appearing for respondent number 1. This appeal is directed against the order dated so and so, passed by the learned single judge in WPC number so and so. The petitioners were serving as accounts assistant cum caretaker on contractual basis in Kasturba Gandhi Balika Vidyalaya. Sorry, petitioners in WPC 7671. You are in which appeal now?
Yes.
You are preferring appeal against the second writ petition.
Yes. Second one.
Second one, sorry. Petitioners in WPC 7667/2022 are working as Chowkidar, grade 4 employees on contractual basis under Samagra Shiksha, Assam in KGVP. These petitioners were appointed on the basis of an agreement for a period of 11 months, which were to be renewed from time to time. The grievance of the petitioner is that they have been transferred from KGV to Netaji Subhash Chandra Bose Avashya Vidyalaya, POSOT NSCBAV, in the same category of post also. The petitioners being aggrieved have challenged this order dated 3/11/2022 before the writ court. The claims of the petitioners were contested by the respondents, who submitted that under the service agreement, there is a specific clause which specifies that the persons engaged either on contract basis or on deputation shall be liable to be posted anywhere also. The learned single judge, upon considering the entire matter, dismissed the writ petition. Being aggrieved, the present appeal has been filed. Also, before us, the learned counsel for the appellant reiterated his submissions made before the learned single judge. Also, we have heard the learned counsels for the parties, and also there was the pleadings on record. We find that from the agreement, where is the agreement?
Yes, 44. Lord.
Page 44. Executed by and between the employer, Ahom Sarvahika Vijan Mission, and the appellant. There is indeed a specific clause
Five.
That they shall be governed by, that during the period of the agreement, the employee shall be governed by all the rules and regulations of laws of the Ahom Sarvahika Abhijan Mission. Also, where is the clause for the transfer?
Transfer clause is not there.
not there, just saying that policy, whatever there.
No, no, no. It is quoted in by the learned single judge, 6P
Lordship,
of the
one,
service regulations.
That's a part of.
page 74, Lordship, of the judgment, Lordship.
No, no, where is it been? It is, this was quoted from clause 6P.
So 6P is the regulation, Lordship.
Where is it? Is it here?
It is not there, Lordship. On the date of hearing, Lordship, I place it before the court, Lordship.
And we have not
Page
given
number,
any
page
opportunity of.
74, Lordship. Page 74, it is mentioned here.
Okay. Mr. Nayok, learned counsel appearing for the mission, submits that the general conditions and services, conditions of service regulations prescribe that a member of the service engaged either on contract basis or on deputation shall be liable to be posted anywhere within the state of Assam or in any other department of the government, corporate body, society, etc. Full stop. This position is not disputed by the learned counsel for the appellant. Full stop. The learned counsel for the appellant has raised a grievance by referring to
Guidelines.
the
Guidelines.
guidelines to submit that some of the posts are reserved for female candidates, like the post of warden cum teacher, the full-time assistant teacher / part-time teacher, etc. But the posts in which the petitioner, the appellants are presently engaged, namely accounts assistant cum caretaker and chowkidar cum mali, no such specification are found that these posts are reserved for female candidates also. This argument on the face of it cannot be accepted in as much as in the absence of any such specification, it has to be held that these posts these posts are gender neutral and candidates from either of the genders can apply. Also, upon careful perusal of the judgment of the learned single judge, we find that the learned single judge has correctly arrived at the conclusion and rejected the contentions of the petitioner appellant. We find no ground to disagree and take a contra view in an intra-court appeal. The appeal lacks merit and is therefore dismissed. No order is to cause.
Item number 28.
Lordship. In this case, we have filed one FPDP yesterday, Lordship. Investigation is in last stage, Lordship. So only signature testing is yet to be completed, Lordship. It will be completed within some reasonable time, Lordship.
Do you say?
So far, Assam State Corporation Department is concerned, madam. The affidavit reflects page 4 of the filed by the CID, madam. But some entire scam for releasing the fund was outcome of the connivance of staff of the Assam State Corporation Limited, Khanapara. So it is the outcome, the findings of the CID during the course of investigation. But so far, the Assam State Corporation is concerned, madam. No steps has been taken up against the supplier regarding recovery of the amount which was released by them. No inquiry was made by the state corporation itself, madam, against the employees or against the supplier. The affidavit is silent to that effect, madam.
What is the prayer in the PIA?
Madam.
Let's street.
Page, my lord. 15, my lord, starts from 15, my lord. Prayer number 2, my lord.
Recovery.
My lord.
What is the stand regarding these
Lord,
prayer clauses number 2 and 3?
because investigation is yet to complete the signature.
You could have instituted a departmental proceeding simultaneously or prevented you from doing so.
That much instruction, actually, as per last order, I am only asking
There is
for
already-
the CIDPS
The
case.
PIL is pending since 2021.
Lord.
What is your stand regarding these two prayers?
Then I need to take this instruction because I am only sought for instruction.
You must have filed an affidavit. What does it say? Earlier one.
Earlier one is also regarding the investigation by the CID lordship. Earlier and which was filed by.
Silent, absolutely.
Silent.
So file a specific affidavit regarding prayer clauses number 2 and 3.
Lordship.
Madam, my lord, department will file, my lord.
Agriculture, I think
Agri-
agriculture department.
Assam State Corporation.
You have filed an affidavit.
Yes.
Yes.
What have you said about these prayers?
Silent. We had filed, my lord, FIR.
That doesn't prevent you from initiating a departmental proceeding.
My lord, so far this departmental proceedings concerned, my lord, that inspection I will collect, my lord, that what action that has been taken care other than, my lord, this.
The council so and so representing the Assam Seeds Corporation shall file a pertinent affidavit explaining the steps taken in reference to, if any, in reference to prayer clauses number 2 and 3 of the petition, PIL petition. List after 3 weeks.
Deeply.
Item number 32.
May it please your lordship.
Yes.
Well, I am appearing on behalf of the MFS Mr. Iskedas.
Mhm.
This matter concerns the progress with regard to the solid waste management plans at Nagaon Miller. The
Mhm.
updated status report is to be brought by the.
Yes, please.
Lordship, in this matter, Lordship, the Lordship, before the district commissioner was to take hold of all the planning and all the setting up of the dumping site, but Lordship, now the same has been given to a consultant. Lordship, the consultancy will give us a detailed project report, which is awaited.
Okay.
Once we get hold of the report, Lordship will open tenders regarding the same, Lordship.
Okay.
For that, we require some time, Lordship.
List this repetition. I will post it in that green bench environment. This writ petition in the bench hearing matters related PIL petitions pertaining to environment issues in the next week.
DP.
Green bench, it's going on already. That's it. No, it's already commenced. Yes.